Hey. All persons have anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you, Ronnie. Good morning. Welcome to the Massachusetts Appeals Court. My name is Judge Desmond. To my right is Judge Hershfang, and to my left is Judge Brennan. We'll be your panel for all 6 cases today. I expect that we'll hear 3 matters and then take a brief break, maybe 15 minutes or so, and then come back and hear the final 3 matters. I see some unfamiliar faces, so I can assure you that we've read the materials and are familiar with your arguments. I've read the cases, and so you're welcome to get right to your argument. You need not give us the facts. However, 15 minutes is yours to use as you see fit, so feel free to do just that. We'll say that it's 15 minutes and there is no rebuttal. And with that, we'll call our first case, which is 24P0170, Commonwealth versus Joseph BOUCHER. Attorney Capone.
Good morning, Justices. May it please the Court, Jennifer Capone for Appellant Joseph Boucher. Mr. Boucher's conviction for indecent assault and battery on a child under the age of 14 should be vacated and set aside because the conviction creates a risk that there has been a substantial risk of miscarriage of justice in this case. The reason that there has been a substantial risk of a miscarriage of justice is because the conviction for indecent assault and battery under the age of 14 is for the touching of the victim's breasts. Yet the jury heard significant evidence of continuous conduct that he touched the same victim's breast when she was 14 years old, going into a little bit after her 15th birthday.
Did the verdict slip, so not guilty on 2 counts and guilty on 1 count?
Yes, Your Honor. I mean, Justice Desmond. Can I say Your Honor?
Either will do. Either will do.
Sorry.
So it sounds like the jury was paying attention.
There's no question the jury was paying attention. This is a situation where I think it's not the jury's fault at all or due to their lack of attention that the verdict is in question. I think that they were not given the tools that they needed in order to reach a verdict that we can clearly see that it was based on the necessary facts. And that is simply because they heard 2 facts of identical conduct, 2 different set of facts. So that even though it wasn't identical in the sense of the victim's age at the time, the way it was presented leaves open the question of whether or not the jury understood they had to limit their verdict to just the events that happened when the victim was under 14.
Why do we think that they might not have?
Because they heard evidence that when she was 14 to 15 years old, at the same time that the charge for touching her vagina was occurring, within those same episodes, he was also accused of touching her breasts. Not exactly intertwined conduct, but the evidence, well, when the victim testified, first she testified that when she moved back in, she was in a different bedroom. She was 14 years old at the time. She testified that Mr. Boucher would walk into the bedroom at night and touch her breasts and then touch her vagina.
So on that, why is it not a more logical inference that if the jury was using that evidence to convict, that they would not also have convicted of the touching of the vagina. Just seems to me that,
Right, so I
because
think,
they're really together in terms of the testimony.
I agree with Your Honor. I think that that's actually the weakest argument that I have is if they found him not guilty of touching her vagina, then they also did not believe that he touched her breasts.
At that time.
At that time.
Right.
Yet, I think the fact that the jury on the first day of trial indicated to the judge that they could not reach a unanimous verdict on count 2 opens up the question for us now and this court now about questions that may have arisen for the jury. I mean, obviously, we can't read into what they thought, but each juror agreed that Mr. Boucher did not touch the victim's buttocks and did not touch the victim's vagina at the end of the first day of trial. Yet, they could not come to an agreement as to whether or not he touched her breasts. The facts on counts 1 and 3 were pretty straightforward. Either, the facts themselves were not contested except to the extent that whether or not they happened at all. So,
Can I ask you this?
Yes.
Just moving to a slightly off topic on that. The judge did not give a limiting instruction as to any of the uncharged misconduct, right?
right, not to any of it.
And as recently as 2025, the SJC in Nascimento said, judge not required to unless the defense asks. I suppose the Commonwealth could ask too, but in this case, it was in their motion, but nobody asked, right?
Nobody asked for a limiting instruction, no.
Can you think of a reason strategically why the trial counsel would not have objected when there was testimony about what happened regarding the breast after 14 and did not ask for a limiting instruction? It seems to me.
I don't see a strategic reason. I think it was an oversight, and I can explain my basis for that further. But I will just say this. If there had been a strategic reason, I think that counsel would have addressed that evidence in some way, but she did not.
Other than to say, hey, the sister was literally in the bed with her at some point and then in the room sleeping lightly because of her little baby when she was over 14, and she told you she didn't hear or see any of this.
Right, but if it was a strategic reason to let the jury hear two separate set of facts distinguished only, under two separate statutes distinguished only by age, I think tactically in closing argument, the focus would have been, you heard all of this evidence that he touched her breast when she was 14, but he's not charged with that.
How about you heard evidence that he was peering at her when she was in the bathroom? You heard evidence that he touched her breast and touched her buttocks and touched her vagina while the sister was in the room, and you heard from the sister who's still close to her, and she says, never happened. I mean, it seems to me that, by at least, I could see why an attorney sitting there would not object because A, they don't want to bring extra attention to it, or B, they're just relying on their theory, which is pile it on and make your story bigger because it just makes it less credible when you have the sister who's in the room saying it never happened. I mean, we're speculating, but.
If that was a tactical, strategic decision, I think it was misplaced. I'm not ruling it out. I don't know what defense counsel was thinking. I do know that at the beginning of trial, these are not facts that I included in my brief. So this is just anecdotal to your honest question. But prior to the jury coming out, when the Commonwealth had proposed a reading of the statement of facts to the jury, one of the requests from defense counsel was to change the language of the touching of the breast to child to then mirror the jury instructions, but then did not seem to follow along with that. And if I can just explain why I think it was an oversight, because these charges were amended. When the complaint first issued, each count was charged as over 14, so that both touching of the breast at that point were included within the statutes, because they were all the same one. And then at arraignment, they were all amended to under 14. And again, both touching of the breasts were charged conduct because they were all the same statute. On the trial date in September 20th, at the end of the motion in limine arguments is when the Commonwealth moved to orally amend count 3, touching of the vagina, to 14 and over. And at that point, the 2 episodes of touching the breasts became 2 separate crimes. And even though there was an oral amendment, the trial was continued, defense counsel did object. The written motion to amend, I believe, was filed October 12th, sometime after the September 20th date. I don't think the parties really put any thought into the impact of that amendment.
There was some discussion about prior bad acts.
Yes.
Right? And so there was a lot of discussion about prior bad acts.
Yes.
And I see that there's no claim of ineffective assistance.
Right. I didn't make a claim of ineffective assistance of counsel because I'm arguing under the standard of substantial risk of miscarriage of justice, and I believe it's the case Commonwealth v. Pelican says that they're 2 sides of the same coin if all of the errors are existing at trial. So really the issue is whether or not the jury was confused by the evidence, and if at this point there's an assurance that they did not consider the second set of touching the victim's breasts or were not influenced by that. And so the substantial...
But the trial evidence, as I read it, is that the touching of which the defendant was convicted, namely touching the breasts under age 14, happened in a very specific way, right? So the trial testimony, both from the victim and from her friend, was that the defendant would open a window. This was when the girls were in a room that had a window out onto a porch. And so the defendant would open the window and reach in through the window while the victim was sleeping and touch her breasts. And a friend testified that she saw the defendant's hand coming in, though she didn't actually see any touching on that occasion. And then obviously the testimony about the later touching that involved both vagina and breasts happened in a different manner, in a different room. He'd had to walk through the room on his way to the bathroom. Some of the personnel are the same. Obviously, the sister's there, but she has this young infant also. When you weigh the substantial risk of a miscarriage of justice, how do you weigh in the fact that there is a real factual distinction between those 2, I'll call them sets of episodes, that the jury heard?
I want to say that the issue that I see is that from what the jury hears is beginning in November of 2011, when the victim was 11 years old, and then the defendant starts touching her breasts every night in the same way, and that goes on for about 15 months. And then there's a gap of time.
This is a pattern of conduct, right? Where she goes to bed, he goes to the front porch.
Right. Every single night.
And starts smoking and starts peering through the windows and reaching through the windows.
Right.
All right.
Then there's a gap in time, but then it picks up again, even though it's in a different way. It's still the touching of her breasts. Now she's 14 or over.
Well, it's not just a gap of time. She moves out, right?
Right. So she moves out for almost 18 months, I think. But even when she moved back in, she was not in the same, in a bedroom that Mr. Boucher had access to her. So,
Right. She was on the sun porch and she could lock the door.
Right. So it picks up again in November-ish or early December of 2014. So that it's almost a 2-year span of time, or between February of 2013 to December of 2014, I would say, is the span of time we're talking where no touching occurs because she does not live there. But the jury doesn't understand, or was not given instruction or given any significance about diverse dates or the fact that those two events were not continuations of each other. So
But
that
they heard the evidence that you just summarized for us and that we all had the opportunity to read, which is there was a period when she was younger, and then there was no touching for a while because she wasn't there, and then she came back, but she was in a locked area that he couldn't get to. And then it started up again. Why isn't that enough to create, I mean, it's enough to create a break for you, for us. Why is the jury less capable than we of figuring that out?
we have the ability or the familiarity with the law to understand that the concept of separate and distinct acts and the continuation of offenses, so that even if both of these incidents had happened under one statute, the jury still would have had to been unanimous on one set of facts or the other because they were broken in time. This is not a situation where it's just diverse dates and there's no clear distinction between the acts, and the victim just knows that when I was between the ages of 11 and 13, this is what happened to me. I don't remember the exact dates. These are clearly two separate and distinct acts, so that a specific unanimity instruction would have been appropriate if requested when they were both charged under the same act.
What do you point to?
I'm sorry?
What do you point to that leads you to believe that the jury was possibly confused?
Because this is a crime that's in evidence, the Commonwealth's using it to prove that he's guilty, and yet there's no criminal charge that aligns with it. Had they included it in count 3, then that would have lessened the confusion.
When you
But
say
they
there's
had-
no criminal charge that aligns with it, I see your time. When you say there's no criminal charge that aligns with it, what do you mean by that?
He was not charged with the touching of breasts on a person age 14 and over. So they had all of this evidence and they needed to do something with it. And like the Commonwealth v. Tingley, it's likely that they aligned it with the identical conduct.
You take issue with the Commonwealth's reference to child?
In their opening and closing argument, I think it was just a further confusion of the age issue. So that normally, I don't think that that would have been a big deal, but it was a piling on effect in this case.
I see that your time.
Yes.
Thank you kindly. ADA McLaughlin.
Good morning. May it please the court, Laura McLaughlin on behalf of the Norfolk District Attorney's Office. The trial judge acted within his broad discretion and absent palpable error to admit evidence of uncharged yet continual acts of the defendant peering into the bathroom and touching the juvenile victim's breast. This was introduced to demonstrate the probative nature of the defendant's pattern of operation, absence of mistake, and to demonstrate the nature of the relationship, which was one of ongoing continuous sexual abuse of the victim
But
between.
there's no claimed error with respect to the prior bad acts, right?
Correct.
Okay.
And here, what you had and what was introduced is evidence of substantially similar misconduct, albeit at different ages and in different bedrooms of the defendant's home, but it was compelling evidence of the pattern of conduct and probative to the relevant facts and relationship, and as found by the trial judge, the defendant's fixation with the victim.
Do you,
We
I'm
got
sorry,
that.
go ahead. Do you concede that or not, that the, what do you call it, peering or whatever, looking at the
I think
victim?
is the term of art, peeping.
Peeping, well, when she was in the bathroom, is a bad act or uncharged misconduct that requires a limiting instruction or not necessarily?
Well, as found by,
The judge wasn't convinced necessarily.
no, and the limiting instruction is only required if expressly requested
No, I
by
get
the
that. I
defense
get that
attorney.
part of it. But my question is, in your view, was the behavior something that should have inspired someone to give a limiting instruction or to request one, more to the point, or not necessarily?
In the Commonwealth's brief, it indicated that it would have been advisable, perhaps best practices, for the trial judge to give a limiting instruction at the time the evidence was introduced and at the time of the final jury instructions. However, that did not occur in this case, and the defendant, by failing to object, waived that perceived error claim.
So then you are saying, so that's a bad act then?
Yes.
Looking at someone, looking at a child when they're in the bathroom from a distance away smoking a cigarette is a bad
Uncharged
act?
contact introduced to show the nature of the relationship between the parties, and as found by the trial judge, I believe his words were the defendant's fixation with the victim at that time.
What if he just said inappropriate things to her? Is that a bad act that requires a limiting instruction? Or if
Depends on
he
what-
sort of looked at her in a way as opposed to just looking at her, if they were sitting in the same room and he looked at her and she described, well, he kind of looked at me like he was really into me. Is that an uncharged, is that a subject that requires a limiting instruction?
Well, here the facts were, it was more than one incident. It was a continuing pattern of sexual abuse.
So say she testified, every time we were together, he was looking at me and he kind of like staring at me and he's looking at me like I'm, like I'm his girlfriend, not like his niece. Is that situation bad act conduct that requires a limiting instruction, or not necessarily? It's just testimony in the...
Not necessarily.
Okay. So what makes peering at her from a distance when she's going into the bathroom different?
Well, it's relevant to the convicted conduct of going outside while the victim was sleeping, standing on a porch, opening up a window, and reaching his hand in.
I'm just trying to get an idea.
Yeah,
Is this a bad act, if you will, legally, or is it just behavior that each side can argue for whatever purpose they want to argue it?
I think the behavior becomes more relevant to this fact because the defendant is going outside under the ruse of smoking a cigarette, which is similar to he's smoking a cigarette at the time he convicts the charged conviction, that it's similar pattern, it's similar nature and scope, it's similar and relevant to the defendant's intent. If the defendant was sitting in the kitchen and looked at her, on those facts alone, I don't think that's a charged, prior bad act. But here where the pattern is substantially similar in his actions of when he conducts those peering, peeping type acts, they're very consistent with his behavior when he commits the indecent assault and battery on the victim under 14.
Can I ask you a question about the jury potential confusion?
Yes.
So the judge made it pretty clear, it seems to me, in his initial instructions that there were 2 charges under 14 and 1 charge 14 or over, and that there are acts that corresponded to each of those.
Yes.
You agree with me there? And then there's a verdict slip that is consistent with that explanation to the jury, right?
Correct.
Then, as often happens, once the judge is done with the instructions, lawyers come up to sidebar. They have a conversation which we can't see quite what it is, but we can infer what it is. That's at the trial transcript 157 going into 158. Wait a minute. Sorry. The judge then repeats the instructions and breaks them down again. However, and that's at, I think, 160, the judge says the second charge is an indecent assault and battery on a person under the age of 15. Do we think that's a Scrivener's error? Or do we think that's actually what the judge said? I'd be awfully surprised, given this judge's experience, and it's not a crime. 15 is not a number that anybody uses for anything. But it kind of jumped at me when I saw that, and I said, And that's to wit, touching breasts. If that was actually given to the jury, does that impact our analysis as to whether the jury may have been a little bit confused by this?
No, Your Honor. I do believe that was likely.
Saw that.
I did not see that. I did not pick up on that. And so I don't have the transcripts in front of me, but I trust that that's what it says.
The second charge is an indecent assault and battery on a person under the age of 15, to wit, touching of the breasts. And the third is an indecent assault and battery on a person 14 years of age or older, to wit, touching of the vagina. It was preceded by under the age of 14, to wit, touching of buttocks.
My assumption would be it's a Scrivener's error. The trial judge is a very experienced trial judge. He is familiar with the charges. He reviewed the verdict slips. The charges that he gave to the jury, both initially and during the final instructions, were correct. I don't believe there's any misleading or confusion of the juries.
Can I ask Panel Chief, can somebody look at that and just submit a letter to say, is that right or wrong? I mean, I could go listen to the FTR myself, but I prefer not to.
I will contact the transcriber in the court about that. But it's
So the verdict slip saying indecent assault and battery on a person age 14, touching of the breast, to wit, touching of the breast, guilty. That's what the verdict slip says, right?
Yes, Your Honor. And the verdict slips also further strengthen the Commonwealth's argument that there was no confusion or misleading. The final instructions, as well the jury's instructions, clearly delineated the charge, the body part that was touched, and the victim's age. The jury is also presumed to follow all of the court's instructions.
And the jury heard evidence about indecent touching while she was 14.
Yes, Your Honor, and the jury was also a very sophisticated jury, that they were able to render verdicts of not guilty on 2 counts, but presuming that they were able to follow the court's instructions and that the uncharged conduct either they discredited or did not really sway their opinions to render those not guilty verdicts. Turning to the issue of the closing argument and opening argument, where the Commonwealth references the victim as a child, the Commonwealth's position is that it did not substantially alter the verdict, or the defendant was not demonstrated a significant level of prejudice. What was put forth was that the victim of the ages that the incidents occurred and the charged conduct was occurring. And unless Your Honors have any additional questions, the Commonwealth would rest on its brief and request that you affirm the defendant's conviction for indecent assault and battery.
Hearing none, the matter stands submitted.
Thank you, Your Honors.
Next on our docket, 24P 1461, Commonwealth versus Anthony Austin.
Good morning, Your Honors. May it please the Court, Edward O'Brien for my client, Anthony Austin. The legal fiction in these cases that these are civil cases, and the reality is that Mr. Austin is serving an indeterminate one-day-to-life sentence in a prison, and therefore constitutional due process protections, obviously the criminal ones, protections are very important in these cases. And Mr. Austin was denied of his constitutional right to present all proofs in his favor and in his defense by the ineffectiveness of his trial counsel. And I will start with a couple of observations. One is the most recent conduct of my client is the most relevant conduct.
You say ineffectiveness of his trial counsel who the judge took time to recognize as a very experienced trial counsel in these matters.
Yes, he did. He said he's very experienced. I'm not arguing counsel's experience. I'm arguing his ineffectiveness representing Mr. Austin. And it is true that the trial judge, this was a jury waive trial. The trial judge was the one who decided to deny the new trial motion. However, it is de novo review on the trial judge's assessment of the law and the facts as it applies to the law. That also is de novo review. And here I'm going to start that the most recent conduct of my client is the most relevant. The Commonwealth QEs, of course, start in with the offenses dating back to 1999, 2011, and however, the information that I brought to the attention to the court, which trial counsel never did, were entries in Mr. Austin's well path, his prison records at Mass Treatment Center within the year before his trial. And those records show that he was managing his mental illness. He was compliant with his...
Counsel, can I ask you one quick question? I don't want to distract you and throw you off your game here, but just what seems to me to be pretty low-hanging fruit is you claim that the attorney was ineffective because they didn't call the expert, but your client refused to talk to his expert. So
Right.
what was the attorney to do? What's he supposed to do with that?
Unlike in criminal cases where you would have a delay because of incompetency of the client, the Nieves case says that since this is a civil case, that the attorney is responsible for making the decisions that the client ordinarily would make. Now, it's true, Mr. Austin had a competency evaluation, and it was determined he could not appreciate the significance of these commitment proceedings. Therefore, it was incumbent and the responsibility on trial counsel to use his best judgment to substitute his judgment and decision-making on behalf of Mr. Austin. So it is not Mr. Austin's fault.
Well, I'm not blaming him. I'm just saying, why is it ineffective for a lawyer when their client refuses to talk to an expert to call the expert as a witness? I'm missing
Because
something
this
here.
expert, Dr. Bard,
Yep.
his testimony is valuable. These cases are decided by, they're all about expert testimony.
Right.
Okay? When you walk into this trial without an expert, you're at a significant disadvantage. Dr. Bard could have rebutted the opinions of the Commonwealth's QEs in certain areas. Yes, some of these, what I raised, were brought up in a very cursory fashion by the Commonwealth's QEs, but they were not fully and fairly presented by trial counsel to the judge. These were stuck in an exhibit that was over 400 pages long, and as the court has acknowledged, these...
And the exhibits, I'm going to interrupt you for a second. The exhibits came in, right? All the exhibits came in.
They did.
And so the trial counsel has to make a decision. He has to say, do I want to call this expert and put him before the fact finder and have it come out that he refused to speak with the petitioner? The petitioner refused to speak with...
That's right, but this expert has a lot to offer.
So he had,
Well,
so trial counsel had to weigh that, right? That was a strategic decision that he had to make. You agree or disagree with that?
the affidavit by trial counsel did not refer to it specifically as a strategic decision.
No, it didn't. My question's different. Do you agree or disagree that he had a strategic decision to make, which was, do I call the expert and put on what he has favorable to help me? But at the same time, he's also going to bring out, or it's also going to come out in front of the fact finder, that the petitioner refused to
Under
speak
the
with.
circumstances here, I would submit, Your Honor, that strategy was not part of counsel's determination. In his affidavit, counsel said he did not call him because he could not give an opinion that Mr. Austin was not sexually dangerous. He does not even mention, he just ignores completely the benefit of Dr. Bard's testimony in these other areas where Dr.
Hang on a second. So how is that not a strategy? Even if it's a strategy, even if the strategy is, well, I got this pile of records, there's 2 QEs that I can cross-examine, and I've got a judge who's sitting here, and do I want to put up a witness who has really nothing to say and maybe off-put the judge who's got to listen to this? I mean, why is that not a strategic decision-making process as to whether to call or not to call the witness?
If you wish to call that strategy, I would say that it was inherently unreasonable for trial counsel to adopt that under the circumstances and facts of this case where he had an expert otherwise available. I'm the one that brought out these opinions. He did not. He did not contact. He had no further contact, according to Dr. Bard's affidavit, after that. He never pressed, trial counsel never pressed Dr. Bard on these other issues that I have raised, which Dr. Bard said actually lowers my client's risk of reoffending.
But
I'm sorry.
I think Justice Brennan's question is, without the benefit of hindsight, because trial counsel does not have the benefit of hindsight, wasn't it a strategic decision by counsel? I am not going to call someone as a witness who can be cross-examined. You never talked to the person. You don't know how he would respond, how these other 2 people have testified. They have spoken with him. They've been able to render an opinion. You're here, sitting here as an expert, but you don't have an opinion. What are you doing here? You can't testify whether he is or is not a sexually dangerous person. How is that not a strategic decision in the moment by counsel? And then the corollary is, if it is a strategic decision, in what way does it not meet the standards of an ordinary fallible lawyer to have made the decision he made?
Because trial counsel never followed up. If he made what the court is looking at to decide whether it's a tactical strategic decision not to call Dr. Bard because he can look bad and be cross-examined, or you never met with him. You can't determine, you can't give an opinion on the ultimate
He says in
issue.
his affidavit that I talked to Dr. Bard, and he said that he could not say that
Right.
Mr. Austin was not a sexually dangerous person. I mean, that's seems to be not terribly helpful.
Right, but what I'm saying, it's unreasonable where he does not ask Bard, what can you testify to? What can you give me? And what he is able to give is absolutely significant because it undercuts the Commonwealth QE's opinion on risk. And the evidence...
First of all, let's bring it down a level. And secondly, so reasonable minds might disagree whether the value of his testimony would have outweighed not calling him or not. Reasonable minds may have disagreed with that. And so it seems here that trial counsel retained an expert, had him evaluated, spoke with the expert, and had to make a call about whether this was going to be helpful or not to his client. A seasoned trial attorney in this area.
If counsel's decision deprives my client of his constitutional right to present a full and adequate defense, then counsel's decision is inherently unreasonable. And it cost my client the opportunity to present expert testimony to rebut the key, as I said, the key testimony of the Commonwealth's QEs. I mean, look at the difference. The trial judge in his ruling denying the motion said, oh, that evidence was, yeah, that was considered, that Commonwealth QEs testified to that. It was Dr. Peretti. Dr. Bell doesn't offer too much on this. Dr. Peretti cursory mentions these records. Oh, he's currently compliant with his psych meds, and he participates in mental health treatment, and that increases stability. Well, what's stability? Who's talking about stability? We're talking about risk, whereas the actual record is assessment. Patient presents low imminent risk to self and others at this time. He has gained increased insight into mental illness, open ability to self-advocate in pro-social manner.
Excuse me, can I ask you, do you agree or disagree with the proposition that the trial judge, in his decision on the motion for new trial, essentially said, if I had heard that, it wouldn't have made a difference to me? And I'm paraphrasing, obviously.
He does never say that. But
Okay,
again,
is that what you read?
so we do
Seems
have
how I read it. Am I reading it incorrectly? You think I'm reading too much into the trial judge's decision on the motion for new trial for him to say that as the fact finder now, if I knew now what I didn't get to know then, wouldn't have made a difference?
Well, here's the thing. I don't think he actually says, had these records been brought specifically to my attention, it would have made a difference. What he said was that information was brought up in the testimony of the Commonwealth QEs. So the court, this court...
And it's in the record. It's in the record that presumably that I read.
As the trial judge to review the record to see whether in fact he is correct. And I submit that that judge is not, because again, likely to reoffend, the Commonwealth QEs harp on the fact that he's non-compliant, that he has they harp on his history, his criminal history. They harp on his non-compliance, his antisocial behavior, his D reports, his aggressiveness in prison. And yet these records, what do they contain? Again, the most recent insight into my client's behavior. He's compliant. He has a better insight into his mental illness and how that relates to his offending.
I understand. The Commonwealth didn't harp on, and he refused to speak with my expert, or he refused to speak with the defense expert. They weren't able to harp on that.
No, Your Honor.
Your time's running out. Do you want to talk about the 99 risk labels?
Okay, so the static 99? Okay. So in his affidavit, counsel says that is his standard of care. He defines it. He said, since Commonwealth versus George case, it is his usual practice to have those risk labels redacted. Well, he doesn't do it. And so there is no strategic consideration here. And in fact, I think counsel says it. Not strategy, he just didn't do it. Now, when
view on the SJC's position on whether that's admissible or inadmissible, the static 99 labels now? Current?
Well, the risk label have changed, is that
Right.
what you're
Exactly.
Okay.
That's what the new risk label is.
All right, the
Exactly.
current ones, so it was high before, moderate, high before. Now, it's well above average risk. Well above average risk suffers from the same infirmities as the old ones. The term is vague. What does average mean? What is well above average? What is the average that we're talking about? And in fact, a colleague last week, it's not in my brief, informed me about the notes of the psychologists that came up with these new labels. In their static 99R evaluation handbook, cautioned, these authors cautioned evaluators to recognize biases, heuristics, which are rules of thumb, educational guesses or shortcuts, and emotional reactions inherent in such common terms. And the SJC in George, they have never ruled on the admissibility of the new these new labels, the risk evaluation labels. And what you're looking at is the static score of 6. That's a 17% risk of reoffense within 5 years, 17%, which means my client had an 83% chance of not offending in the first 5 years. And I would submit this is more than a semantical difference. The emotion that impacts it impacted the trial judge because in his decision he mentions it not once but twice. So I would just say, if you're told by your surgeon that you have an 83% chance of dying versus a surgeon that says, well, you know, you're not going to have that surgery. So I would suggest that counsel, he never brings up these to the trial judge. He doesn't cross-examine the Commonwealth QEs on these records. He never argues it in closing. And the trial judge in his decision never even mentions these new records.
I think we'll have to leave it there.
Pardon?
I think we'll have to leave it there. That's your time.
All right, thank you.
Thank you, Attorney O'Brien. ADM McGrath.
Good morning, Your Honors. Jocelyn McGrath for the Commonwealth. I would like to start with Nieves, because I think there are a few things that my brother said that I just don't think really apply here. Nieves isn't a substituted judgment. Nieves tells us that a counsel, defense counsel, can actually assert the rights of the defendant. And in this case, this defense counsel asserted the defendant's rights more effectively than the defendant would have, because the defendant lacked a rational understanding of what his defense would need to be, because he lacks insight into his conceded condition of pedophilia. So in a sense, he got the best of both worlds. He basically had a defense attorney who had created the best viable strategy using the Commonwealth experts to unpack the only viable defenses that this defendant had. Mr. Austin received incredibly effective assistance of counsel.
The favorable things that Dr. Bard would have been able to testify, did they come in through the records?
Absolutely. I feel that Commonwealth QEs were very fair in describing that Mr. Austin, in his last year, had an increased mental stability, that he did gain a certain amount of insight into his mental illness, and he was compliant with his drugs. But even while he was compliant on his drugs, the most recent conversation, so I agree that the most recent conduct is the most important. So those conversations, which I have to say, I went back to the reports because I had tracked the trial transcript in my in our brief. But when I went back to the reports and really saw the language that Mr. Austin used when he was having very open conversations with these two Commonwealth experts, he had such a distinct lack of insight into his condition of pedophilia. He basically had a compartmentalization of how much he felt. He said that risk about reoccurrence was obsolete. And yes, he described still being in love with the 13-year-old he had offended with, and actually the idea that he might seek him out in the community now that he was overage.
Do you have a position on whether the new Static 99 labels are admissible at trial in SDP cases?
Of course they are. They're completely admissible. I think until we have a published case, this is just going to be, it's a really solid second issue. And these cases are so important that I really feel like, of course, a defense attorney is going to use whatever is available to them. And I respect that. And I think you have recently ruled yet again and tried to unpack it yet again that this is an error, and even if it were error, it would be a substantial risk of miscarriage of justice, which with this overwhelming evidence would really, wouldn't factor in. I think the best strategic decision that defense counsel made for Mr. Austin was to have a bench trial, was to have a jury waived trial, because anything that happened would be basically contained by the experience of the court. And there's so much deference that we can give to the court that was a very robust container for a very difficult type of determination. I really think that there was really not much other angle than ineffective assistance of counsel. You really wouldn't get far with not having enough, insufficiency of evidence. With this massive record, what you really had to do was go into the anomaly. The anomaly here was we had an incompetent defendant, and Nieves took over. Nieves is a very interesting sort of background that it basically, the bedrock of Nieves is due process. And so whatever happens, Nieves gives us at least the grounding of due process. Our position is that the defendant received due process. He did not receive ineffective assistance of counsel. He received excellent assistance of counsel, and he has received actually really good appellate counsel as well. And I really have very little else to say.
Then we'll leave it there.
Thank you very much.
Matter stand submitted.
I'm not going to just stand there for a second.
Okay.
Can we do the same from time to time?
Third matter on our docket is 25P0143, the Commonwealth versus Messiah LEGGETT.
It's not my chair downstairs.
Attorney McDonough.
Thank you, Your Honor. Good morning, Honors. May it please the Court. My name is Jaleese McDonough, and I represent Messiah LEGGETT. What happened on February 4th of 2021 was an unnecessary tragedy, and it's human nature for someone to want to be punished for the death of a 16-year-old girl, but Mr. LEGGETT was not culpable for her death. I'd like to dedicate most of my time today as to whether there was sufficient evidence to demonstrate that manslaughter occurred, and then I'd also like to address the detective's improper opinion coupled with the Commonwealth's misstatement of the evidence in closing.
So, first of all, tragic case. This is a tragic case, no matter what lens you look at it through. The pictures are tragic, the events are tragic, this is a group of young people. I mean, horrible case. But I want you to pick up where you left off, which is the government's arguments.
Yes, Your Honor. I'd like to address both of the Commonwealth's theories as to the wanton or reckless theory of, since the jury did find him not guilty as to the battery count. They presented two separate theories as to how this could have been wanton or reckless conduct. They started off with the theory that Mr. Leggett put the firearm to Ms. Andrade's head and pulled the trigger, and by the end of the trial had also offered the theory that simply trying to take the firearm from Ms. Andrade constituted wanton or reckless conduct.
Is presenting alternative theories inherently wrong? I mean, I'm not sure it's the best trial strategy, but
Your Honor, I don't believe it's inherently wrong, but I think it demonstrates the lack of proof for the Commonwealth's case. I think this case obviously comes down to the reasonable inferences to be drawn. And
So if no one saw it, what's wrong with saying it either happened one of two ways?
Well, we do, again, Your Honor, I don't think there's anything wrong with saying it may have happened one or two ways.
Not that
But
no
I
one
think
saw it, but the
where
two people who saw it were not available.
I think where
clearly,
this
too.
court and the SJC has repeatedly said that any inference has to be reasonable, and if there's two competing inferences, then the Commonwealth has not proven their case beyond a reasonable doubt, and we can draw such competing inferences as to what the evidence demonstrates that I'm not sure that the Commonwealth has proven either theory beyond a reasonable doubt.
So if the competing inferences lead to the same result,
But I don't agree that they do lead to the same result, Your Honor.
so clearly this is a circumstantial evidence case, right?
Yes, Your Honor.
And we look at the evidence in the light most favorable to the government, correct?
Yes.
All right, go ahead.
And Your Honor, I would first address the theory that it's wanton or reckless to try and remove the firearm from her hand. The Commonwealth seems to concede that in order to prove this theory, Mr. Leggett had to have known the firearm was loaded. Their entire argument comes down to that proposition. They argue in closing that it was wildly reckless for Messiah to attempt to take a loaded firearm away from Elijah. So if we look at what evidence there actually was that Messiah knew or should have known that the firearm was loaded, we have the Commonwealth points only to two factors. They point to the fact that Kenny had removed the magazine in the video, but Messiah is standing behind him at that point. There's no evidence that Messiah could see that the firearm was loaded. And then we have that they were all in the room together for about 3 hours. But you have to assume that the magazine was taken out during that time and Messiah actually saw that the firearm was loaded. But
So
we have,
can I ask you,
Well,
no,
I don't know that we have to assume that, but perhaps. I mean, there was some evidence that they were playing with the gun. They were passing the gun around. Everybody was holding the gun and playing with it and pointing it at each other and at themselves from room to room.
yes, Your Honor, and I would make 2 points addressing that. One, the witnesses clearly indicated that Messiah was the only one that they didn't see actually playing with the gun and being that reckless with the firearm. And two, I think it cuts against Messiah knowing that the firearm was loaded because Adama specifically testified that they had been pulling the trigger and the firearm was not shot during the night. So that would lead a reasonable person, Messiah, to believe that the firearm was not loaded.
So right after the gun discharges, what does Messiah say?
Your Honor, he does say, "What did I do?" But we're talking about a teenager who just witnessed a firearm go off and she's being shot in the head.
So you're saying that's the natural response for a teenager is to say, what did I do?
Your Honor, I don't know what the natural response would be in that circumstance. I don't think any of us know.
But that's a fact that you have to deal with, right? You can't just overlook that.
But what did I do? That could mean a whole realm of things.
What do you think it means here? What do you
Well,
think
Your
it
Honor,
means here?
he tells the police that he's attempting to take the firearm from Elijah. They're both kind of grappling with the firearm at this point and it goes off. I think,
So he told the police that he was attempting to take the firearm from the young girl.
yes, Your Honor,
Apologize for forgetting her name. What was her
Elijah.
name? Elijah. And that's what the government argued in part, right?
In part, yes.
Okay.
And that was wildly reckless. But they seem to concede that in order for that to be a wildly reckless act, Messiah would have had to have known that the firearm was loaded at
So
that point.
on that, is it your position that the video where certainly your client was behind Kenny,
Yes.
but that definitively demonstrates that he could not have seen what Kenny was doing? Or is that a jury question, really, to look at that and draw their own conclusions from it?
Your Honor, if we're resting the entire case on whether Messiah could see the magazine at that point, he's clearly standing behind him. And I don't think the absence of proof does not prove a point. And I think that's a lot of the issue with the Commonwealth's arguments is a lot of their arguments rest on the absence of evidence. They're saying proves the opposite point. There's the issue with...
Well, I think on that they're saying that clearly, given the positioning and the proximity of the two, of the one to the other, how could he miss the fact that the gun was being loaded?
So-
I think that seems to me what the import of that video is. And why is that not something that's properly argued, and if so, properly inferred by a fact finder in the light most favorable to the Commonwealth?
Your Honor, so looking at the video, Kenny takes the magazine out, flashes it to the camera, and puts it back while he's standing behind him.
Right.
I'm in no way conceding that Messiah could see what happened at that point. But even still, after that point, the magazine, they're shooting the gun. They're saying that they're pulling the trigger. Adama says that they had been pulling the trigger after that point and the firearm did not fire. So I think given that hours have passed at that point, I don't think we can say that that definitive moment proves that Messiah knew at the time that he's standing in the corner of the hotel that the firearm was loaded.
No,
But
not
doesn't-
definitively, but, excuse me, but does...
Or even a fair
The question
inference,
is
Your Honor.
whether any rational juror could reasonably infer in a light most favorable to the Commonwealth that that provides the link. That seems to me, that's the relevant legal question.
Your Honor, I don't think we can say beyond a reasonable doubt that with two competing inferences that proves that the firearm was loaded. And Your Honor, just to take a hypothetical that he believes that the firearm is loaded. So now we have a 16-year-old girl who's intoxicated playing with a loaded firearm who has already put the firearm to her head at some point in the night and pulled the trigger. So is it wanton and reckless at that point to attempt to remove a firearm from her? Yeah. So the alternative is we know, so we're all looking at this in hindsight. So if we're looking at it in hindsight and we know that if Messiah stood right there and she put the gun to her head and pulled the trigger, we know it would have went off. We know she would have shot herself. So is the fact that Messiah attempted to take the firearm from her wanton and reckless, even though this ended in a tragedy? I'm not sure that's proof beyond a reasonable doubt that that's wanton or reckless
I
conduct.
think part of your argument relies on your having chosen one of the two theories of prosecution. And I don't blame you. It's obviously the better theory for your client, and both were available on the trial record. There is also a theory of prosecution in which it was your client who held the gun to this young woman's head. That theory is supported by his statement to the police in response to the question, who had the gun when she was shot? He answers, me. But like, well, she did first, but then me. And then he also says, quotes Ms. Andrade as saying, I know you guys wouldn't shoot it or stuff like that, which also, viewed in the light most favorable to the Commonwealth, tends to indicate that he was holding the gun. So how, again, we don't know what happened here, but the Commonwealth has presented two theories. How, if you look at it that way, how can your client prevail on appeal?
Your Honor, so I was planning to address that argument next. I wasn't attempting to skirt. I don't think,
Oh, I know.
I think that's actually the weaker theory of the Commonwealth's case. We have Messiah saying throughout the entire statement, I don't want to mess this up. He's just seen someone shoot themselves. He's a teenage gentleman. He continues to say, I don't want to mess it up. I don't really know what happened. He says, me, but like, well, she did first, but then me. And then he goes on to say, I don't know how to explain it. She was playing with it again. And he's telling them that she's playing with the firearm, he attempts to take it from her, and he's trying to explain exactly who's holding it at the time that it goes off. And he's kind of saying, I'm not really sure, it could have been her, it could have been me, but he's trying to take the firearm from her. So he's not denying that he touched the firearm, he's just saying he doesn't know how it went off, he did not pull the trigger.
So you agree that, I couldn't agree with you more that is subject to interpretation. And the point is whether one or all of us would have come down differently if we were sitting as a fact finder is not the issue, right? The issue is whether any rational juror, taking what you've just described in the light most favorable to the Commonwealth and all the inferences favoring the Commonwealth, could reach the conclusion that this jury reached beyond reasonable doubt.
If I could also argue, or I could address the other points that the Commonwealth says points to the evidence that he actually put the firearm to her head and pulled the trigger. So the other statement that Your Honor pointed out, the statement about, well, I know you wouldn't shoot it. For one, Messiah was the only one who gave the police that statement, and he said that he and Kenny were standing there. So the logical inference when the firearm actually was fired, Kenny was on the other side of the room. It wasn't at the exact moment when this is occurring. Messiah also says that Elijah was the one who was actually holding the firearm when she made that statement. So we can't we can't infer the opposite of that. We can't infer that Messiah was actually the one holding it.
Is there any import, from your perspective, it seems to me that was the Commonwealth's argument, at least in part, that not only does he then say, what did I do, but then he, at least inferentially, went and ditched the gun. He took the
Your
gun.
Honor, I would take a lot of issue with the fact that he ditched the gun.
I'm just saying,
Let's not say ditched.
Yeah.
Let's say he
Put it in the
moved
snow.
the gun from where it was to another location. Do you agree with that?
So, no, Your Honor, Messiah told the police that all he did was move the firearm to the bathroom of the same hotel room.
Isn't that moving the gun to another location? Didn't I just say that?
Yes, Your Honor, but he did not move it out of the hotel room, out of the hotel itself. And we have a circumstance where this is a dangerous item, and he moves it to the bathroom.
Well, it was a dangerous item before it discharged.
I agree with that, Your Honor, but the evidence that there was some kind of inference that Messiah brought the firearm out of the hotel was completely refuted. The Commonwealth actually kind of messed with the evidence a little bit to that point. Adama testified
I don't understand that, because at least as I recall what I read, it was discovered along his path of travel, and it was sticking up in a way that looks like it was put in the snow by somebody.
But, Your Honor, Adama admitted that she was the one who brought the firearm and placed it in the snow. And the victim's sister did come forward and say that Adama and Kiara went to her home the day after and said that they were the one who disposed of the firearm.
Remind me why he moved it to the bathroom?
So he tells the police that he panicked and he picked up the firearm and moved it into the bathroom. But I don't think that tells us one way or the other that, for one, it doesn't tell us his intent or what's going through his mind or what happened at the time of the event. I think the fact that a teenager panics and moves it adds little to the equation for the Commonwealth's case.
If it were in her hand, it strikes me at least as a little unusual if it were in her hand when it went off, for him to then take it out of her hand and move it to the bathroom. I can see why a juror might reject that.
So, Your Honor,
notion.
the Commonwealth does argue that in closing, and I don't think that was a fair inference based on the evidence. I did quote to a study that says that 69% of people who commit suicide, actually the gun falls out of their hand. 21% of the cases it does.
Sorry, I missed the last part. That
that
61%.
it falls out of a person's hand.
Okay.
21% of the cases it does stay in their hand, but those people are sitting down. So I think the fact that we have someone standing up and the firearm falls out of their hand, I think is a likely scenario. And it wasn't I don't think
That was not before the jury.
It was not, but I think.
It certainly wasn't an intentional suicide.
I'm sorry?
And this certainly wasn't an intentional suicide.
An intentional act?
Intentional suicide.
Oh, no, Your Honor, but I think if we're arguing that the firearm was in her hand at the time and then he pried, I think the Commonwealth used the word, he pried it from her dead hand and it was a ridiculous claim, I don't think that was supported.
And I want to take you back for a minute to a legal analysis. Are you arguing that it is insufficient as a matter of law to support a conviction of involuntary manslaughter if the facts are, and I understand you don't agree with these facts, but if the facts are, or you may not, that someone is holding a gun that may be loaded and playing with it with someone else who is trying to take it away, playing with it in the region of the head of the first person, is that insufficient as a matter of law, in your view, to support an involuntary manslaughter conviction?
Your Honor, I think the closest cases we have are the Russian roulette cases, Atencio, and the other cases that are cited. And I think a lot of what the court looks to in those cases are the circumstances leading up to it. And in all those cases, the defendants were the ones encouraging the playing with the firearm, encouraging the games. And the evidence here is that Mr. Leggett was the one who was not encouraging.
What is your answer? Do you think that's insufficient or not?
To try and remove the firearm from her or to be playing with the firearm while it's loaded, it would be my...
Well, there's testimony that they were play fighting, right? And then there's also his statement that he was trying to take it away from her. So let's try to neutralize the language of the hypothetical. They are engaged in some kind of physical tussle involving a firearm that may be loaded that is near her head.
Your Honor, I think there's too many facts unanswered from that hypothetical to know one way or the
No,
other.
they're all
because I think-
answered. That's the beauty of a hypothetical. I get to make up all the facts.
Yes, Your Honor, but I think we have so many more facts here that show that he wasn't playing with the firearm, that he twice took it away from her leading up to this. He wasn't engaged in all of the playing and pulling the trigger and putting the gun to the head to give the same level of he's engaged in the play fighting that we have in the other cases where they said it was involuntary manslaughter. Those cases specifically say if the defendant removes himself from the game and says, I'm not playing, he's not liable for involuntary manslaughter.
And
But we go one
here-
step further and we have Messiah trying to take the gun from her and not participating in the game playing.
Well, I mean, I don't know that that's consistent with the hypothetical, right? My hypothetical was that there's some physical grappling going on around the gun. Do you deny that that was happening? Put aside, let's say he had the best intentions in the world. I don't question that. But there was some physical grappling going on. Is that inadequate as a matter of law to support a conviction for involuntary
I
manslaughter?
think under these facts it is, because we have the circumstance where what was he supposed to do in the alternative? Was he supposed to just
Step
let her
away?
put the gun to her head while she's taking a selfie and pull the trigger?
Well, isn't that what they had been doing all day or all evening? Isn't that
Messiah, the witnesses said that Messiah was not engaged in playing
he
with the
wasn't,
firearm.
but everybody, he wasn't, apparently, I don't know. But that's what was going on here. I mean, this is a group of young people who play with guns. That's what they do. They play with guns. We got them on video playing with guns. We've got the girls bringing a stun gun. We got the guys bringing a gun, somebody bringing a gun, and we got them on video playing with guns. So this is what they do. So it's not hard to imagine a scenario where somebody ends up getting hurt. That's why we don't play with guns, loaded or unloaded. And so here you have a scenario where it seems that he and Elijah were in a separate area away from the rest of the group, teasing each other, playing with each other, messing around with the gun, and the gun discharged, and the young lady is dead as a result of it. Nobody's saying Messiah's a bad person. Nobody's saying he intentionally killed her. He's a bad guy. It's an unfortunate, horrific circumstance that was so easily avoided if we just don't play with guns and don't glamorize firearms,
But
which
does
is
that
all I
mean-
see in these videos.
But Your Honor, does that mean that Messiah all of the individuals in the room should be the one doing 6 to 12 years? He's the only one that there's evidence of was trying to take the firearm away from Elijah earlier in the night before this even happened.
I understand, and that's looking at the evidence in the light most favorable to the defendant. That's what that is.
Commonwealth versus Gonzalez says we do actually need to look at least some of the we can't just draw unreasonable inferences in favor of the Commonwealth. If there's concrete evidence undermining an inference that they're asking the court to draw, then that's an unreasonable inference. And when there's evidence that Messiah was not the one who was playing with the firearm, I think it's an unreasonable inference to draw that he was actually then all of a sudden playing with the firearm and putting the gun to her head.
I think we got it.
Okay. Thank you, Your Honor.
Thank you, Attorney McClellan. Attorney Paris.
Good morning, may it please the court. Molly Paris on behalf of the Commonwealth, asking this court to affirm the defendant's convictions. I'd like to acknowledge the trial prosecutor, Caitlin Tolbert, who's with me today. Starting with the first issue, there was sufficient evidence that the defendant engaged in wanton, reckless conduct, specifically by pointing the gun at the victim's head, and that conduct caused the victim's death.
We know that he pointed the gun at her head?
We
What
do.
evidence do we have that says he pointed the gun at her head?
We do, Your Honor, and I'll address that now. First of all, we have the two admissions. First, after the gun goes off in the corner of room 1534, what did I do, what did I do? Then we have the defendant's admission to police that he was in possession and therefore control of the gun when it went off.
Neither of those things suggest that he pointed the gun at her head.
We also have testimony from Sergeant Detective Nina Jefferson that this wasn't a hairpin trigger, that someone needed to depress both the safety tab and the trigger for the gun to fire, that this was not a hairpin trigger, meaning that it required more than 1 to 2 pounds of
Can I ask,
pressure.
was it just to clarify that testimony, was that they had to be done simultaneously, or could the safety have been flipped off while the kids were playing with the gun?
They needed to be depressed simultaneously.
Okay.
And that there were no mechanical defects in the safety or the trigger. We also know from the DNA criminalist, the forensic evidence, that there was dark human hair fragments in the slide of the gun. And the jury could reasonably infer that those belonged to the victims, where the medical examiner testified that she had sustained a gunshot wound to the head, where Sergeant Detective Lewis testified that the hair fragments stuck in the side of the gun were similar to those protruding from the hole in the wall.
Can I ask a hypothetical? No, you go ahead. Hypothetical that's close to Justice Hershfang's, but I don't remember it exactly, so let me try a slightly different one. Hypothetically, if this young woman had the gun and was playing with it, and the defendant tried to remove the gun from her hand, and it just went off, just on those facts, in your view, is that sufficient legally to support a manslaughter, an involuntary manslaughter conviction on this theory?
Without any admissions, without forensic evidence. I think I'd need to know more, but what I can tell you is that the jury was instructed on accident and they rejected that.
No, but listen to that,
Right.
that question, which I think is a fair question.
Thank you.
Because in that question, there's no intentional pointing the gun at her head, which is what you led with. And so that's what let's tease that
Yes.
out. They can be playing with the gun and it can discharge and it can hit her in the head. That doesn't mean he was pointing the gun at her head.
Yeah, that would still be wanton and reckless conduct.
So that's my question. So
yeah.
if she is doing things with the gun and he looks over and says, what is she doing? She's going to shoot herself. And he goes over and grabs her hand instead of just standing back, but he grabs her hand to try and wrestle the gun out of it. And in the process of doing that, the gun obviously becomes pointed toward her head because the bullet passed through her head, but it goes off. Is that behavior, is his behavior, assuming that's all that it was, sufficient legally to sustain a conviction for involuntary manslaughter?
I think it would be, and that was
Okay,
what was
extend-
presented.
walk me through it.
That was what was presented to the jury
Right.
under the theory of a battery, which was how the defendant, which was argued by the defense at trial, that they were grappling over the gun, and the jury was free to discount that as they did because the witnesses in the room, Kiara, Kenny, and Kevin, who were all sitting by the couch, didn't hear any grappling. What they did hear was a gun go off, and then Messiah say, "What did I do? What did I do?"
Though they did hear play fighting, how is that different from grappling?
I think it would be louder, but regardless, the jury rejected any loud noise. I think Kiara testified that she saw them play fighting with their hands and didn't see a gun at that point. But I think regardless here, where the Commonwealth's, where the jury convicted, and we know from the special verdict slip that they convicted under the theory of wanton or reckless conduct.
So that's my question. Is it wanton and reckless to try to take, if you know it's loaded, we're not, I know that's not being conceded, but if you have reason to believe a gun is loaded and someone is waving around and pointing it toward their head, is it wanton and reckless to try and remove that gun from their hand, at least theoretically, legally? Given the possibility, or here, the eventuality that it goes off and kills someone.
I think it could be without knowing more information, but I think what we have here and taking the evidence in the light most favorable to the Commonwealth, what were the admissions were the ballistic testimony, was the forensic evidence, and also from the medical examiner, we know that the trajectory of the bullet was in a downward left to right path from which the jury could reasonably infer that the defendant being taller, the victim being right-handed, it would have been unlikely for that to happen. The jury also could have considered that the victim's hairstyle on the night in question was slicked back, and that based on Sergeant Detective Nina Jefferson's testimony as to how the slide worked, how it moved forward when a bullet discharged, that the only way that her hair, which had been slicked back, would have been tangled within that firearm as depicted in Exhibit 67 would have been if the firearm was held up against her head.
If it was her hair.
Correct, and that was a reasonable inference for the jury to make. And there was plenty of testimony as to getting into issue number 3 as to why that hair wasn't tested.
Can you address the Attorney McDonough's argument about the evidence that the defendant was aware that the firearm was loaded?
Yes,
The
Your Honor.
positioning in the video and the other?
Yes. So as to the selfie video, I think what we're ignoring here is that how a selfie video works is that the camera would have been facing the defendant and Kenny, so he would have been able to see, even if Kenny was in theory, and we don't know, but this was a question for the jury factually, if Kenny was in front of him, he still would have been able to see this from the video, which would be mirroring what would be
Because
happening.
in order for
Because
him
it's
to
a
be on the video, he would have had to be positioned so that.
Yes, because it's a selfie video, so
that
I
he's
think
not.
When in time was that video taken?
9:30 p.m., so about an hour, hour and a half, a little less than 2 hours before the murder, or excuse me, before the shooting. So first of all, it's a selfie video. Second of all, it would be a reasonable inference where, again, the magazine was a different color, and based on what's depicted in Exhibit 73 of Kenny removing the magazine, flashing the ammunition, and then reinserting it back into the firearm. But I think regardless of whether the firearm was loaded or not, I can point this court to Tucker, which I understand is unpublished, but it's citing Macaulay that, quote, intentionally pulling the trigger of a gun pointed at another, even under the mistaken belief that the gun is unloaded, is nothing short of recklessness. So regardless of whether he knew that that gun at that time while they were in the corner of the room was loaded or not, it still would have been reckless. Regardless of whether they were playing with it earlier in the night and nothing happened. And by the way, Adama was in
The other room.
the entire evening in room 1532.
And these young people was drinking and smoking?
Yes, Your Honor, but I don't think that undermines, the evidence in the light most favorable to the Commonwealth here.
What do you say to the detective's testimony regarding stellate, and I might not be pronouncing it correctly, but the gunshot residue on the head that came in, I guess, in response to a Bowden attack, but I don't know if that's supposed to be lay testimony or what's going on there?
Yes, it was proper lay testimony. This was a veteran homicide detective with 20 years of experience, someone who responded to the scene. Here where the defense mounted a strong Bowden defense as explaining why various investigatory steps weren't taken, he was allowed to explain why a shooting reconstruction and the distance determination testing wasn't done. In part, he says, based on the stellate defect, which in his experience would indicate a close contact wound. But regardless, I think
No, let's not go to regardless yet. And why should we believe him? Because of his experience and his expertise in these investigations?
I don't know if it's a question for this court to believe him. It's a question of whether the jury could credit
Why
that
did the Commonwealth
expert.
call him for that evidence? Why?
I mean, he was called on direct because he responded to the scene and made decisions as to what was tested or not. Then the defense raised their Bowden defense through cross-examination, and then on redirects, this testimony came out as to why he didn't conduct the shooting reconstruction or the distance determination test.
So given that testimony and given the judge's, I think, 3 limiting instructions, seems to me properly, on Bowden, could the jury actually consider that witness's testimony about stellate or star shape substantively, or only as it related to the officer's investigation, the detective's investigation? In other words, do you get my question? It's kind of a...
I think the latter. I know that the Judge Ames instructed the jury that they consider his evidence to understand the investigative process and the reasons why certain actions were taken or were not.
So he could have been completely wrong. I mean, based on the ME, he was wrong.
I mean, I would disagree with that premise because the ME just simply testified that she saw a stellate defect, this meant a star shape, and she couldn't conclusively say one way or the other, so I don't think...
She said you couldn't conclusively say one way or the other with respect to this type of a firearm, right? Isn't that what the expert said?
Yeah.
Okay, and he said you could. That's why he didn't do more.
I don't think he said he could. I believe his testimony was from his training experience. This would generally, in his experience, represent a close contact wound. And if I may, I'd like to explain why there was no prejudice here, because there was no dispute that the victim and the defendant were in close contact. No one was disputing that they were in the corner of 1534, as in defense counsel's opening statement, closing statement, the defendant's own admissions in speaking with police. No dispute that they're the only 2 people. No dispute that this is an extremely confined space. So I think regardless of whether that testimony was admitted or not, when you consider the judge's forceful limiting instructions, there can't be any prejudice. I would also like to just briefly address counsel's point as to the disposing of the firearm and the claim that Adama disposed of the firearm. That would have been not possible for several reasons. First of all, Adama testified for the first time at trial that there was this second gun, but that second gun was, it always stayed in room 1532, which was the room she stayed in at all times, and that after the shooting, she never went back into the other room, 1534, where the victim was shot. And so from the evidence, it was a reasonable inference where the defendant admitted to possessing the gun and removed it from the room, given that after the shooting, we know that Kevin and Kenny, who were both in the room where the shooting occurred, went to Downtown Crossing. They didn't pass by Spruce Street, so they couldn't have disposed of the gun. We know that Nikki and Emanol stayed on scene with police and called 911, so they didn't dispose of the gun. And we know that Kiara testified that she never disposed of a firearm, never saw a firearm. And so the reasonable inference here, where Adama was always in room 1532, and the defendant admitted to being in possession of the firearm, was that he disposed it where it was found in his flight path shortly thereafter the shooting.
Does it matter? I mean, this strikes me as one of those things that we are not in a position to resolve as an appellate court, right? I don't know what was going on with Ms. Rampersand and this, spontaneous second gun, and why she would have said that suddenly if it wasn't true, why she would have disposed of the black and gray gun if it was the only gun. She had only met the defendant that night. It seems unlikely she would have been motivated by any desire to protect him or relationship. But I mean, that's all a long way of saying these are all the things I don't know, and I don't think we're going to know. I think the things we do know are that the gun was found on the path of 3 of the 4 people, right, of whom Ms. Rampersand was one and the defendant was another, and it was taken out of the room. Does it matter that we don't know those other things?
I don't think it does. I only addressed it because it was raised by counsel and also because it comes up in closing. But
it wasn't was it a consciousness of guilt argument? I just don't recall.
No,
Pretty dense
no.
record. So it wasn't an argument. There was an argument here that he knew he did it, and that's why he took the gun out and put it in that he took the gun out of the room. That was not.
There was some argument in closing that this is how the gun got out of the room, but there wasn't a consciousness of guilt instruction.
Right.
And no, to Your Honor's point, I don't think it's necessary for this court to resolve because it doesn't impact the 2 sufficiency arguments. Whether he possessed the gun at the time of the shooting, it doesn't matter in terms of the disposing. That would go more towards a possible possessive construction theory, but that wasn't at issue here. Unless the court has any further questions, I would rest on my brief.
Hearing none, the matter stands submitted.
Thank
Court's
you.
in recess.
All rise, please.
Thank you kindly.
Court is open, please be seated.
The next matter on our docket is 25P0177, Bryan Oliveira versus City of New Bedford.
Good morning, and may it please the court. Christopher Trundy for Bryan Oliveira, who is requesting this court to overturn an adverse summary judgment ruling in his retaliation discrimination case out of the Bristol Superior Court.
How did they specifically retaliate on him?
So as the court knows, there's a lengthy history that goes back a couple of years, and of course the salient topic is what happens within that 300 days of him filing his MCAD complaint. And within the 300 days, he makes multiple complaints to managers, starting with the deputy chief, then the chief himself, and much later, and simultaneously to human resources, and much later at the end of his tenure to the mayor. The response to all of those complaints is to do nothing. And so the retaliation is based on the claim that there's a duty of the employer to investigate what happened, what he was complaining about.
I'm sorry, go, no,
Go ahead.
I just want to make sure that I read the same case we're talking about, because I thought that he had reported this horrendous conduct.
Yes.
Which is the homophobic comments and
Right.
slurs while at the policeman's ball.
That's correct. And so,
And I thought that after he had reported it, he was inquired whether or not he wanted to go forward by way of a complaint, and he did not. And that the department elected to go forward nevertheless, given the magnitude of the wrongdoing.
right,
Did that happen?
yes.
Okay.
So,
So there was some investigation, some
and
speaker was held to,
so that's background in this case. The officer, Jones, is not a defendant in this case. His conduct predates the 300 days. His conduct was egregious. It's documented in the record. It was ultimately reported, I believe, to the deputy chief, Oliveira, at that time, no relation to the plaintiff. And it is a fact that Mr. Oliveira, a police officer, was asked if he wanted to make a formal complaint. He declined.
more than once?
I don't recall if it was actually more than once, but he was reluctant to make a complaint against another police officer, all of which is understandable. And we applaud, and it's in the brief, we acknowledged that what they did as an investigation there was the right thing to do, and they did an investigation, and they...
So can I just to focus here, the issue, as I understand it here, comes from Jones's alleged statements disparaging your client and saying that he was trying to get Jones fired.
So
That's
now
that's the starting point here.
Well, now you're
No?
moving ahead in the
Yeah, well,
in
that
the
seems to me like the
timeline.
retaliation.
Yeah, so
Okay.
there's the incident that happens at the policeman's ball.
Right.
They investigate that.
He
There's
gets the 3 days.
There's a discipline that is not directly shared with my client, but he learns through the grapevine. He's not happy with it.
Right.
He then learns that Jones is making statements about him, suggesting he's a snitch and tried to get him fired and all of this, the type of thing he would be concerned about when he declined to make the formal complaint.
Yep.
He complained about that. The record is clear that after he complained, evidently somebody, maybe Deputy Chief Oliveira, told Jones to knock it off, but nobody ever actually investigated it. Jones was not disciplined. There was no investigation. There was no caution, nothing.
Can I cut to a little bit,
Sure.
jump a little bit ahead, because it seems to me the
And that,
key issue here, what the judge found, or the basis of the judge's finding, was that there was no your client didn't suffer any adverse employment action. So what is the adverse employment action, which it seems to me, unless you disagree, is required for him to at least, under McDonnell Douglas, kind of uphold his prima facie case of
The
retaliation?
adverse employment action is that they chose not to investigate later in the timeline.
Yeah.
Okay?
How's that an adverse employment action?
Because what it did is, because,
Is that
If-
goes into the constructive discharge, or is
yes.
that? All
So
right.
what happens is you have this behavior back a year and a half or so with Jones. Jones then makes these disparaging remarks. There's a complaint about that. Jones stops making them as far as we know.
No, so I get the facts. My question is, again, just, I'm trying to get an idea of, there's
So
no
what
demotion,
happens-
wait a minute, there's no demotion, there's no docking of his pay, there's no, even though they say you may have to go work with Jones, they don't make him work with Jones.
Well,
So
so there is
what
case law that and it's within the statute, a threat can be retaliation. And this is not a threat to change you from the night shift to the day shift.
And so the threat is, hey, you're going to have to go work with
We're going to make you
Jones.
work with your harasser. And this threat was made a couple of times. There was no legitimate, non-discriminatory reason for even making that threat by his new boss, who was Jones' long-term superior.
Okay.
And,
And then your client says, no way, absolutely not
Oh.
working with them, and then he doesn't work with them.
well, no, then he goes to the deputy chief and says, this is what the captain, one of my captains, is saying to me.
That's
No.
Sousa?
And then he goes to
That
the
Captain
chief.
Sousa?
No, the person who's saying it was Sousa. Yes, the person he spoke to initially was the deputy chief, then Oliveira, later became the chief, not
Different
relevant to
Oliveira,
this.
no relation, I presume.
Right, again, there's, and then he goes to the chief Cordero, who is a defendant, who administered the original discipline to Jones. And he says, this new boss of mine is made multiple threatening remarks having to do with Jones and an animosity towards me because of Jones. And this is a problem for me. And what Cordero says is, I don't know why he would say that. No investigation ever follows. And
So just so I'm clear, investigating whether or not the captain was telling him you're going
Yes.
to have to work with these guys, or
Right.
whether or not the other guy was saying,
no, we're talking, there was no investigation of Jones' comments, but then there was no investigation of the captain's, Sousa's comments. And what,
Can I
say
start?
investigation, nobody asked Sousa, hey, did you say you were going
This-
to make him work with these guys?
no, what Cordero testified to, actually what Oliveira stated under oath was that Cordero said simply, I don't know why he would have said that. And that was the end of it.
Sousa said those things to your client in December of 18 and January of 19, right?
That's correct.
And that's more than 300 days before January 14th of 2020, which is when he filed his MCAD complaint. Fair?
Yes.
So why are those not time barred? Why is that not?
Well, I would concede that it would only survive if it was somehow viewed as part of a chain of conduct.
So what is the chain of conduct or the ongoing conduct that you say occurred in this case?
Oliveira goes,
A date or the dates of?
well, in May, Oliveira makes formal complaints about these threats, and
Yep.
nothing happens. That is followed by the incident where he is being interviewed. He explains to Cordero that this is creating a situation for me where I don't believe I can stay in the force I'm looking to transfer within civil service to Taunton. At that point, it becomes known, he's called in by the Taunton chief, told, we have information that you have a problem with your captain. He has never had a problem with his captain, never expressed to anybody he had a
What
problem
about
with his captain.
Sousa? You didn't have a problem with Captain Sousa?
No, Captain Sousa had a problem with him.
All right. Well,
That's a difference.
He didn't have a problem with the fact that Captain Sousa told him you're going to have to work with the
Well, he
guy
didn't-
who
he
made
wasn't-
homophobic remarks.
Well, no, but
Probably should have had a problem with it. if he
all
didn't.
conflict isn't necessarily bilateral here. And
If he didn't, then that can't be the starting point for some action, right? If he didn't have a problem with Sousa saying that to him.
oh, no, he had a problem with Sousa saying that to him, but he did not report that to anybody except the deputy chief and the chief. So When he learns this from Taunton, he goes back to Cordero and says, and it's a reasonable inference that he was then passed over for the hiring.
Well, no, I'm not going to go there with you because there are a couple of facts that I think are inconvenient to you in trying to take that step. One is that it was never identified that anyone had actually said that to Taunton, right? They looked into it and found no evidence of anyone having said that to Taunton.
That is not consistent with the record.
Okay, I appreciate your correction when I'm done with the second thing. The second thing is that Taunton PD said we didn't offer him the position because he's a detective. He's been working on a DEA task force. He's got this incredible experience, and the job we have is a patrol position, and we don't think that it's appropriate to take this overqualified person. He's going to be miserable.
Well, that's what they ultimately said after they received the information. That was not the disposition of his application that had been pending successfully up to the point where this communication came in.
Could you point to one fact in the summary judgment record that supports the proposition that your client was passed over in Taunton because someone from New Bedford communicated to Taunton that he had a problem with his captain? Is it, where? I didn't see it.
There's an email from the chief saying, before we go any further,
right,
we need to deal with this issue, which he brings them in with other people.
This issue, that's all he says.
No, he says, I don't recall the exact language,
Right.
but
But where in the record does it say that the source was anybody at New Bedford PD or in the town of New Bedford?
So,
which seems to me you'd need to have.
Well,
I mean, if the Taunton police chief got it from some random guy in the street or his bunch of guys in his department.
This is the problem, because by not investigating this, let's just back up. As a matter of law, Bryan Oliveira was entitled to be protected against collateral attacks against him in retaliation, whether it's in the workplace or external to the workplace. That's well-established law. His application for an external job cannot be interfered with by folks from New Bedford. So
that's my question.
If we start there.
Yep,
and then the second,
so far I'm with you, 100%.
Right, and then now, nobody investigated the source of this information that was received by the police chief.
Well, I'm looking at the Statement of Undisputed Material Facts in Volume 2 of the Record Appendix on page 299. Number 95 is, Vecina then spoke with Chief Cordero and asked that he reach out to Chief Walsh to determine who, if anyone from New Bedford, had said anything negative about plaintiff. That is admitted for purposes of the motion. Number 96, Chief Cordero contacted Chief Walsh and asked if he or members of his department had communication with anyone from the New Bedford Police Department relative to plaintiff's candidacy. Response, admitted for purposes of the motion. 97, Chief Walsh told Chief Cordero that neither he nor anyone on his command staff had any communications with anyone from the New Bedford Police Department relative to plaintiff's candidacy. Admitted for purposes of the motion. They then follow up with Lieutenant Kagan, who had, if memory serves, it's not on this page, participated in the same DEA task force and was familiar with your client, asked him if he had spoken to anyone from the Taunton PD. He adamantly, this is 101 on page 300, Lieutenant Kagan adamantly denied talking to anyone from the Taunton Police Department about plaintiff, admitted for the purposes of this motion. And it goes on, 104, Chief Walsh stated that he had not received any negative information from anyone at the New Bedford PD regarding plaintiff, admitted for purposes of the motion. You say that I'm wrong about that, and I would love to know where the evidence is in the record that there wasn't an investigation or that someone from the New Bedford PD did badmouth your client to the Taunton PD.
Well, the record is that essentially that one chief called the other and he said, nobody spoke to me. The testimony of the chief himself, when I took his deposition, was, that they had received information, but he couldn't remember as of the date of the deposition years later where that information came from. What I would suggest to you is nobody attempted to find out where the information came from. A mere denial. What's that?
The call to the chief was not an attempt? I mean, it may not have been terribly
Well,
successful.
they never, at that point, nobody asked the chief, the claim, we don't have the chief's version at that time. We have Cordero's version years later.
What additional investigation would have been helpful here? How could they
Well,
have?
first of all, the investigation should have been done by somebody other than Chief Cordero, because, first of all, Cordero is deeply involved in this. This is one of his people who directly report to him, and it should have been transferred either to HR or to Internal Affairs.
Okay.
And it should have been done as a formal investigation. I'm out of time.
Good. Thank you.
Thank you. And I love the tie.
Gentlemen. Maglione?
May it please the court. My name is Christine Maglione, and I represent the defendants, appellees, the City of New Bedford, Joseph Cordero, and Adelino Sousa. Your Honors, this court is well aware of the facts. See that from this argument. So we're going to just go right to the heart of the matter, which the court has already identified. There's no adverse employment action in this case. When the employer was faced with a complaint of discriminatory, harassing, reprehensible conduct, they acted immediately and on their own volition, disciplined and suspended the perpetrator.
Do you think that let me put it a different way. Do you think it's time barred? Let's start with whether...
Time barred?
Yes,
well,
before we even get to whether there was adverse action.
If the complaint was based on that protected activity, it would be time barred. However, it's never time barred to look at an employer's response and whether or not there was retaliatory animus. So I think that's pretty important to look how an employer and defendant Cordero operated. This is a department and an individual who, on their own volition and on its own volition, is initiating an investigation. So in terms of the other incidents that are time barred, the September 2018 complaint about any alleged comments by Detective Jones and any of Sousa's comments, those are time barred.
Seems to me that's the sole basis, though, of the retaliation. No? What are the other bases, or what's the other basis or bases of retaliation?
We agree.
Oh.
We agree. There's
All right,
no,
so in
there's
answer
no
to-
basis there.
So, okay,
there-
to Justice Desmond's point then, your position is that the entire retaliation complaint is time barred because the behavior on which it's based,
Well,
or no?
I think it would be time barred, but if there had been alleged interference with, there might not be it would be difficult to have a causal link at that time, but if those facts existed in the record, then it would be harder for us to overcome summary judgment. But as
So let me ask you this. If the behavior of Sousa, which was the basis, at least as I understand it, of the retaliation complaint, right? Sousa's
his comments,
and take those, or the failure to respond at the time to Jones's statements about him trying to get, the plaintiff trying to get him fired, right? All right, if the response based on those actions is time barred, is that your position?
I think they're time barred, and I also think that neither of them rise to the level of an
Fair enough,
adverse
I got you
employment
there.
action, or
Yep.
that there's a causal link.
Then if in fact they then later interfere with his, which I'm not saying they did, but if they interfere with his attempts to get a job in Taunton, what does that mean? What's the import of
I
that
see your
behavior?
point.
Is that behavior potentially retaliatory, and does that revive the retaliation claim?
I see your point. If there's no, if the protected
Because I
activity.
wasn't quite sure what it was, but thank you. No, I think,
No, I understand. If the protected activity is either the complaint in
Yes.
2018, either September or April, and there's no protected activity to retaliate it against, then there can be no retaliation claim. I agree. However, that could be another cause of action, I assume, and maybe there's, an argument which I also think would fail, that there's a continuing violation. However, I think none of those are the facts here. And I think we have a very clear record based on the testimony of the Taunton police officers that there was no interference. I mean, that's what the record, that's what those deposition proved, that was consistent with what Chief Edward Walsh said initially, that there was no interference, that there were no negative comments. And he also said that while at the deposition he couldn't name names, he remembered that it was not from somebody that was a current member at the New Bedford Police Department at the time of the relevant action, but that he learned the information that there was perhaps some friction with some unnamed captain or some interpersonal issues with the plaintiff and some unnamed captain. But he got that information from one of his own officers at Taunton or from somebody who had worked previously at New Bedford. So the count just falls apart there. Also, the aiding and abetting count fails because it's derivative. It's also duplicative, even if the retaliation claim would survive, which it will not. But in both of those cases, the trial court properly granted summary judgment. And if there are no further questions, I'll rest on my brief, unless you have other issues that you want to discuss.
I think Officer Oliveira eventually got on with Attleboro.
He transferred eventually to Attleboro Police Department. Yes.
that he's wishing right now he went down to Florida, but I think that was another option, right?
Yeah, I'm
Right
sorry. I
about now,
couldn't-
I'm just saying with the,
Oh, yes.
with the cold weather is my point.
Thank you, Your Honor.
That one didn't land very well. There we go.
Next up is 25P0149, Diane ALICEA versus Katie DISHNICA and another. I may have mispronounced that name. And I understand that the appellees have requested to split their time, 14 minutes and 1 minute. Is that correct?
No, Your Honor.
The appellees? That's correct, Your Honor. Okay. So typically, unless both appellees have filed briefs, then they don't get to argue. Future reference. We'll now hear from Attorney Salgado.
Yes, thank you, Your Honor. May it please the Court. Jason Salgado from Greater Boston Legal Services for the plaintiff appellant, Ms. Diane ALICEA. With me is Alana Gelfman. The issue in this case is not whether Ms. ALICEA's employer had good cause to fire her. The case is also not about the importance of protecting...
We agree they had good cause to fire her.
Your Honor, I believe that's not the question in this...
I'm saying, we agree that they had good cause to fire her. You say that's not the issue here.
That's not the issue here. I think even if we assume that she had good cause, that doesn't lead to her disqualification from unemployment benefits under Section 25E2. I think that's a judgment for the employer, and that's a judgment the unemployment statute leaves to the employer. I believe there's factors here. Again, this is the first time she's warned about the conduct that I might not personally discharge a claimant in this situation, but understand the importance of protecting patient privacy and the employer's decision to do so here.
Attorney Salgado, can you do me a favor, because I'm old, and just pull that a little? Thank you.
Thank you, Your Honor. The issue here is whether Ms. ALICEA's employer met its burdens to show two separate things. First, that she engaged in deliberate misconduct, and second, that she did so in willful disregard of her employer's interests.
So let's start with, did she engage in willful misconduct?
She did not, Your Honor.
All right, so hold on.
And also...
So, hold on.
Of course.
So, I thought the record supported that she was aware that personal information, private information, was something that was to be safeguarded by employees of the BMC.
Correct, Your Honor. So there's a finding that Ms. ALICEA is...
She was aware of that. And her practice, as I understand it, was because of the volume of her work and the speed of which she needed to tend to it, that when she would take periodic breaks, I think they were breaks, or when she stepped away from her computer, maybe they weren't breaks, or stepped away from her computer to do something else, she would, rather than log off from the computer, which she had to sign in with her own personal ID and password, she would just shrink it. And just for the factual background, while that, on one of those instances, another, I think, employee used her computer to pull up that employee's personal information. And that's attributed to her because it was her password that was active at the time that this information was retrieved, right?
Correct, Your Honor.
And she knew, I think, that she was not supposed to, well, she knew that when she stepped away, she was supposed to log off. Is that fair to say?
So, Your Honor, I think there's not substantial evidence to support the conclusion that the employer conveyed that specific expectation to Ms. ALICEA in this case. The written policies in the case are at page 73 of the record. They speak to...
Which one of those 3 policies do you think this action fits into?
I think that's the problem. It fits into none of them on their face. The policies themselves speak to things like unauthorized access, copying, distribution of the policies themselves. The employer's witness, even and the review examiner at 98 to 100 of the record, indicate that the policies on their face don't seem to cover Ms. ALICEA's specific conduct. What we have is testimony from the employer's witness, also around 98 to 100, is that annual modules training modules provided by the employer indicated that employees were responsible for their login information or passwords. We don't have the content of those modules. We don't have testimony that the specific conduct at issue here, minimizing the contents of the screen rather than locking or logging out, was barred by the employer's policies.
Does Ms. ALICEA concede that she knew she was supposed to log off?
No, Your Honor. So I believe to some, the testimony you're referring to is at pages 111 to 113 of the record. She says to some extent to a question about whether she was supposed to step away from the computer while it was unlocked and whether that was barred by the policies. In the next pages, she explains that she believed minimizing the contents of the screen was the equivalent of physically locking it or logging out of it.
That may be a misbelief on her part. That doesn't...
That's correct, Your Honor. That might be a misbelief, but that's the critical factual issue for deliberate misconduct. It's the employee's understanding of the employer's rules or policies. Even if she was mistaken about the employer's rules or policies and was misinterpreting them, that might well justify her discharge, but that's not the issue under Section 25E2.
I get it. So this is where I need to untangle for me. She knew, I think, that the better practice for her would have been to log off. To some extent. Her answer was to some extent. Is that what I heard you say? Right?
Correct. That was right.
Right. So she knew that. And she elected not to do that, knowing that. So that's a deliberate act, right? We agree that that's a deliberate act. I know I'm supposed to do this, not getting into why she did or didn't, but I know I'm supposed to do this, and I'm not doing that.
Your Honor, I believe that's a volitional act. I don't think that's a deliberate act under the statute. What the statute requires is knowledge that the employer's, the specific misconduct at issue is barred by the employer's expectations. I don't think we have findings regarding that, and I don't think we have substantial evidence that the specific conduct at issue, even if it was a misinterpretation of the employer's policies, was actually barred by the employer's policies. If we look at this court's decision in Weber, we know that findings and evidence regarding the specific conduct that's barred and that led to the termination are required to support disqualification under the deliberate misconduct provision. If we look at Garfield, again, the issue there was an employee that left the store unattended while he had to leave. The court said there was no deliberate misconduct in part because he had no notice of the apparent requirement specific.
So when I get the cases. So when she says to what extent, what are we supposed to take from that?
Your Honor, I believe Ms. ALICEA was expressing that, again, if we look at the rest of the testimony in full context, that she believed minimizing the contents of the screen was sufficient to comply with the employer's policies. She may well have been mistaken about that, but that's not, that doesn't amount to deliberate misconduct in willful disregard of the employer's interests.
Is there anything in the record about how close the shop was? In other words, whether 3 people in the office or 300 people in a larger space, workspace?
Your Honor, I don't believe there was anything about the size. I do know there's testimony, I believe at 120, that these are kiosks essentially that you would have to chart in and then step away from as you go do other duties. I will note, Your Honor, that there's also the employer concedes that Ms. ALICEA was never warned against this conduct before. That's at page 102 of the record. It's also in.
When you say this conduct, you're talking about the minimizing
Correct, Your
the
Honor.
screen, minimizing the window instead of logging off her computer.
Correct, Your Honor. And that's also in its written submissions 42 and 48, even though the review examiner finds she had engaged in this conduct before.
Were they, would you say, I'm sorry, what was the last part?
Even though the review examiner had found that Ms. ALICEA had engaged in this conduct before, that, as Your Honor alluded to, this was a practice. I don't know how frequent it was, but she had never been warned against it in the past.
Never held to task for it prior.
Correct, Your Honor. So again, the knowledge of that this kind of violated the employer's expectations, that wouldn't support that finding.
Does the statute require that she have some ill will toward the employer?
Yes, Your Honor, that's exactly right. The employer has to show both deliberate misconduct, which I think is the knowledge piece we're talking about, and understanding that the specific conduct at issue is barred, but it also requires the employer to show willful disregard of the employer's interests. We know from the SJC's decision in cases like Jones that requires looking at the employee's attitude, their motivation essentially in carrying out the misconduct. In that case, a claimant, an employee, had deliberately disregarded the direct orders of his superior, despite having been warned in the past that doing so could lead to his termination. But the SJC found there was no willful disregard as a matter of law, based on the finding that he himself had deemed the distribution work he was doing to be of paramount importance. Now, obviously, that was an incorrect judgment. It led to his termination, but that still showed that the motivation was essentially to serve the employer's interests.
Can I ask you, is there anything in the record here that disputes or undercuts your client's stated motivation, which, as I recall, it was because it's rather inefficient every time I step away to basically log off, and then I have to log back on, and I'm trying to get things done efficiently. Anything, I mean, I know that the examiner, the hearings officer, I'm sorry, chose to discredit or disregard that, but is there anything that affirmatively says the opposite that you're aware of?
Your Honor, I don't believe there is. The employer did not submit any evidence regarding Ms. ALICEA's motivation. The only evidence regarding her motivation was at pages 118 and 119 of the record, which is her testimony that she had to work quickly to serve the large flow of patients. And again, I think importantly here, like in Jones, we don't just have a lack of subsidiary findings that Ms. ALICEA intended to disregard her employer's interests. We have a finding at finding of fact number 12 that she was desired to work more quickly. The review examiner accepted, based on that testimony, that was her motivation, and like in Jones, that compels the conclusion that she did not intend to act.
We agree with you. Is this a remand for them to fill out those findings, or is this just a reversal?
Your Honor, we believe here a reversal is appropriate, like in Jones, because there's a finding of fact number 12, that Ms. ALICEA intended to work quickly. That was her motivation. And like in Jones, the finding...
I'm sorry, you're saying that there was actually a finding of fact, I probably saw it and I just don't remember it, that she intended to work quickly.
Correct. That's a finding of fact number 12, and that compares favorably to in Jones. The SJC looked at the finding that the claimant himself deemed the distribution work he was doing to be of paramount importance. Again, it's a very similar finding regarding the claimant's motivation that compels the conclusion that they did not act in willful disregard.
Sorry, can I just ask you to shift gears for a moment? You made an argument about the sort of mid-hearing change of theory by the employer, and I'm interested in hearing what you think the legal hook is there. Is that something that they were not permitted to do, and if not, why not, and what is the consequence?
Of course, Your Honor. So I think the legal issue there was the review examiner's lack of express credibility finding dealing with that inconsistency in the employer's testimony. If we look at the termination letter, Record Appendix 73, the written questionnaires from the employer at 41 to 51, and the employer's initial testimony, they all say that Ms. ALICEA herself improperly accessed this information. Now, the review examiner could accept the employer witnesses kind of change in testimony and change in reason, But to do so, she has to essentially make express credibility findings and deal with that inconsistency. That's the SJC's decision in Harridge in School Committee of Chicopee. You can't rely on some testimony, disregard other parts without explaining it. That essentially makes appellate review inconsistent. We think that requires remand, but we think there's enough here, again, to require reversal. And we know.
So that speaks to whether she actively retrieved the information or whether another employee retrieved that information from her station.
So it speaks to the employer's belief and the reason they terminated her. I do want to note we have express findings from the review examiner at 17 and 18 that Ms. ALICEA did not, in fact, access the information herself. She did not know that the coworker accessed the information when she did so.
But that's equally offensive to the BMC, right? Whether it's her who does it herself or whether she left it in a condition that somebody else could do it. That's
I think
alleged violation.
Your Honor, I think, again, looking at the reason the employer terminated her and whether it had good cause or was justified, that's not the issue here, whether that's equally offensive or not. I think the issue here is whether the employer met its burdens under Section 25E2, and dealing with that inconsistency would be a requirement for the review examiner.
Is there any, I'm going to use the words due process, but I don't really mean it in a constitutional sense, but is there any argument or is there any procedural requirement in the, whether it be in 25E or elsewhere, that the claimant be notified at or before the hearing of the reason that she's being denied benefits?
Your Honor, certainly unemployment has due process protections under Section 25E. It's governed by Chapter 30A in the informal hearing rules, so certainly there are requirements that claimants have the opportunity to confront evidence presented against them. I do believe it's acceptable that employers provide testimony. These are informal hearings during the hearing, and that the claimant then has a chance to rebut it during the hearing. I think the problem here with the inconsistency is the lack of findings from the review examiner explaining the inconsistency. I do know we asked for several forms of relief depending on the different argument. We do think reversal is warranted. Like in Jones, if the court does find, though, that there's no substantial evidence as to either the deliberate misconduct and willful disregard prong, and again, the employer bears the burdens of production and persuasion as to both to justify disqualification, reversal is also warranted. If the court disagrees with either of those, however, but believes there's no subsidiary findings to support either conclusion or that there's legal error with respect to either of the prongs, then it should remand to the agency.
So the deliberate misconduct was not logging off. Is that what it is, or are you suggesting that the deliberate misconduct was accessing somebody else's, accessing the other information?
So, Your Honor, so I think even if we assume that the misconduct at issue here is not locking or logging out of the computer, there's not sufficient findings or substantial evidence to support the conclusion that that was deliberate within the meaning of Section 25E2. There's certainly not substantial evidence or that it was in willful disregard.
So when you say deliberate, not within the meaning of 25E versus the lay view of what deliberate might mean, which is intentionally not doing something, right, is a deliberate act.
Correct. So, Your Honor, I think to briefly address, I think deliberate within Section 25E requires a degree of intent, and we know that if we look at the Still decision interpreting the knowing violation prong of the statute, which was a less culpable state of mind than deliberate. We know that it requires...
I don't know if you do criminal work. Is it sort of the analog volitional being general intent and deliberate being specific intent?
So, admittedly, I don't do criminal work, but that is how I think of, that I think there's been an interpretation that deliberate itself has been interpreted to mean volitional conduct, as in the conduct itself was intentional, when we know from the case law it requires a degree of intent. It requires knowledge that the specific conduct at issue is barred by the employer's conduct. And then the willful disregard provision looks at motivation.
So we may have said it already 3 times, but just one more time for me. She deliberately did not log off, right? That was, she intentionally shrunk it. She knew I had to protect it, so she didn't just leave it up. but instead of logging off, because it takes too much time to come back and log back on, I'm going to just shrink it while I go and do my thing. That was a deliberate thought process, and she had to think about that and do that, right?
Yes, I'll stick to volitional, if it's okay, Your Honor. I apologize for fighting, but I think there's a particular meaning to deliberate in this statute.
Which is the malice part or the ill will part?
No, which is the knowledge of the specific conduct at issue and that is barred by the employer's policies. The malice and ill will part goes to the motivation and willful disregard.
So is the specific conduct at issue not logging off?
No, I think it's not logging off while minimizing the contents of the screen. I think we have to deal with the Ms. ALICEA's belief that's uncontested that minimizing the contents of the screen was sufficient to comply with the policy. That was her understanding, and I don't think we have substantial evidence that the employer conveyed that minimizing the contents of the screen was not sufficient. Again, she's not warned about that specific conduct in the past, and the policies on their face don't cover this policy, that conduct at all.
I see that's your time.
Thank you, Your Honor.
Oh, good. Thank you. Attorney Fierro.
Good morning, and may it please the Court, Assistant Attorney General Meredith Fierro on behalf of Director DISHNICA.
So in the record, I saw that she received a letter, Ms. ALICEA did, that identified the policies that she was in violation of. Is that fair to say?
Yes, Your Honor.
Okay. And which one of those policies do you say this conduct fit into?
I'll answer your question, but first I want to say that the pertinent inquiry here is the employer's interest.
Which one of those policies?
Sure. It is the policy requiring employees to maintain the privacy and security of our patients' health information at all times. And this is the way that the employer expresses its interest in maintaining the protection of patients' private medical information, which of course is a legal obligation under HIPAA. There's no, because the appellee, this case falls under the deliberate misconduct and willful disregard of the employer's interests, there's no requirement of an actual policy. That's a separate prong under Section 25E2 for a knowing violation of a reasonable and uniformly enforced policy. That a basis of disqualification is not an issue here. So, yeah.
Wait, hold on.
Oh, yeah, no, that's a, yeah.
Yeah, I just,
Thank you.
I don't think this is what you're saying, but I want to make sure this is not what you're saying, which has already started off probably more awkwardly than either of my colleagues would have. I apologize. You are not claiming that BMC was under no obligation to train Ms. ALICEA that she had to lock or log off, are you?
I'm not, Your Honor.
Okay. So what are you saying then?
All I'm doing is clarifying that the basis for disqualification in this case is deliberate misconduct and willful disregard of the employer's interests.
Right.
Here, the employer's interest is maintaining the confidentiality of protected patient medical information. That's a legal obligation, and it's expressed in its policy. I apologize if I'm confusing the court, but I only wanted to clarify that there's a separate disqualification prong of a knowing violation of a reasonable and uniformly enforced rule.
And that's explicitly disclaimed by the examiner.
Exactly. That was the only point.
Do you disagree with Attorney Salgado's distinction between volitional acts and deliberate acts under this particular statute?
So my position is so there's the two prongs, deliberate misconduct and willful disregard. Here, okay, the misconduct is stepping away from the computer without logging out or locking the computer.
And how did she know that specifically those were the acts that were required in order to safeguard the information? Because what if she stepped away and logged out, but she left her password on her desk, and then someone could come in and just access her computer?
Well, I think
where does it stop, I guess, is the question.
Sure. I think what's important here is the employee's own testimony. The employee never said that she had no idea that this was required of her, that she was never trained in this.
She thought she complied, right? I'm looking at 111, 112 of the appendix when she says, you just minimize the screen to where nobody can see anything. Check, done, we're good.
Well, that was her justification, but
or her understanding.
Well, the ALICEA also admitted that she was aware that if you simply minimize the screen, someone could come in and simply reopen it.
Right. So again, to my hypothetical,
yes.
if you log off but leave your, like many of us do, perhaps, leave on your desk what you think is in your office and reasonably secure, because you can't remember, because you got to change your password every however months, your log-on and password information on a yellow sticky on your computer. What if she did that? But so she logged off, but the information is there for some other employee who presumably is under the same obligation to access, and then that employee uses her credentials to get back on, reopen it, and then access a patient record. Is she still in violation right there?
I think employees are expected to use their common sense in understanding the employer's expectation.
Okay, so why is it not common sense to say, hey, I'm in an office with people who are all supposed to be protecting, we're all on the same mission here. It's not like I'm sitting out in a Starbucks with my computer and I'm leaving it open and minimizing the screen. I'm in an office with other employees who have the same obligation, and I shouldn't be leaving it up obviously displayed, but if I minimize it when I walk away, that does the job. Why is that not common sense?
If you're in an office with a closed door, those are different factual circumstances in this case. The factual circumstances in this case that these were kiosks in a hallway.
Yep.
And I think it's reasonable to expect that an employee would know that if they're just minimizing their screen and stepping away without logging off or locking their computer, that someone could come in and access confidential patient records when they're...
Why is the onus not on the employer to be specific in terms of what the expectations are before they, certainly they can terminate, but before they seek to deprive someone of their unemployment benefits?
Again, I would come to ALICEA's own testimony that she does not state that she was never trained on this. She does not state that they received annual trainings, and this is in the record, and that in fact this employee received the training 1 month before the incident in question on the responsibility to maintain the confidentiality of patient records and the responsibility to maintain their own
login. One more
login.
question. But there's no evidence in the record that the training included log off or close it down, right?
The actual training is not in the record,
You just
Your Honor.
expected that that's common sense and everybody should figure that one out on their own.
Correct, Your Honor.
Okay. Sorry.
All right, so when I first read the letter, I wasn't sure which one of those policies her conduct purportedly fit into. Still not sure I am, but we'll leave that for a second. But the action had to be in, what did you say, in willful disregard of the employer's interest.
Correct.
But I thought her action, at least in her mind, was in the best interest of the employer's interest. I thought finding number 12, I think it is, which Attorney Salgado pointed out more than once, was that they accepted the fact that she felt it was faster or more efficient, I'll say more efficient, to shrink it so that you could keep up with the flow of her work demands.
That is a separate interest. But importantly, again, I would come to the facts that this involves privacy in a hospital setting, which is very important, and it's a legal obligation. And there's no facts here suggesting that there were competing interests. For example, it would be a different...
competing interest in her mind, right? I mean, that's what now we're starting to try to get into, what was she thinking when she was doing it, right? That's important.
And the law requires that. I mean, that's what Jones says.
The law requires willful disregard of the employer's interest. Right. The fact that that there's a variety of shortcuts that employees could take that may further an interest in efficiency doesn't negate the intentional disregard of the employer's interest in maintaining the confidentiality of patient records.
I'm not sure how you balance necessarily that those things are congruous. How you can say that she's doing one thing which she believes to be in the best interest of the employer, and yet she's willfully disregarding the best interest of the employer.
It's the employer that sets the interest and expectations for the employees. And so there's no evidence in the record that ALICEA was trained, that the desire to work efficiently was, of course, for any employer, that this is an interest. I'm not denying that.
And we're talking about the BMC.
Yes.
Okay.
But here we have a legal obligation under federal law to maintain the confidentiality of patient records. And it's for the employer to determine what is the paramount interest. And again, there's...
In terms of whether they fire her. I mean, they could fire her, which they did. But the question here, it seems to me, I think, and to step on Justice Desmond's question, is the next step, we need to look into her, as best we can, mind and infer things about her intent. and about her purpose. And how do we arrive on the facts that were found here and on the testimony or the evidence that's in the record at a willful, you know,
Disregard of the employer's interest.
Thank you, disregard of the employer's interest, yeah. As opposed to a negligent.
And deliberate misconduct, because they're separate.
They are
and
separate,
it has to be
yes.
both.
Yes,
Initially, when she applied, they gave her the insurance, right?
that's correct.
All right.
But, so again, so I would point, Your Honors, to pages 111 and 1112 of the record with ALICEA's testimony, because I think that this is important to understand, what her testimony was of her actual awareness. She was asked, were you aware of the employer's policies regarding confidential patient information? She answered, we're all aware of that from the very beginning. That doesn't mean we were accessing it out of malice. Asked again, were you aware of the policies? She answered, everyone's aware of the policies. She didn't say, well, I had no idea that the policies didn't require me to step away and, not lock my computer or log out.
That's not, I mean, we've all made records before, right? This is not a great record. If you say, were you aware of the policy? You're not making a very good record. The good record is, were you aware that the employer's policy required that you either lock or log out of your computer before you left the area? So here, could it mean that? For sure. Does it definitely mean that? No, right? So she's aware that there are policies. She's been trained. Presumably there are slide decks that are used for these annual trainings that could have been put in evidence. Maybe, probably, it would have a slide that says log out or lock, but none of that was before the examiner, and none of it is before us. So what we have, I think, is a record that she was aware that she was supposed to protect it, that it was important, that she should not leave it open. We also have her saying, if you minimize your computer, or you're not leaving anything open, you just minimize the screen to where nobody can see anything. What do you have that says that she knew, and now I'm turning to the language of Jones, that when she did that, she was doing it in willful disregard of the employer's interest, taking into mind her state of mind at the time of the misconduct?
Sure. So I'll start with her testimony and then I'll turn to Jones. She was asked the question that Your Honor posed, were you aware that leaving a computer unlocked was a violation of the employer's policy? She said, to some extent, yeah. When asked to follow up what she meant, she said, the way I perceived it was, she didn't say I had no idea, no one trained me. She said, the way I perceived it was, as long as no personal information, I'm not giving other people's personal information. She was asked, but you were aware that if someone could come in and reopen the screen and have access, is that right? And she said yes. In terms of Jones was very different factual circumstances. There, the employee was doing one task, was asked by the employer to do a separate task. That task was not time sensitive. The task he was doing was time sensitive. And so the employee continued to do his time-sensitive task and then did perform the employer's task after. So there was no disregard of the employer's interest. Maybe there was a disregard of the specific instruction by his supervisor, but the interest in having all of the work done was still further. There was no harm. The other difference would be there was no legal obligation in that case that the employee was disregarding.
Well, but the employee in Jones had already explicitly been told, you're being insubordinate, and if you do this again, you're going to get fired, right? So that employee was on notice in a way that the employee in this case was not. And I would think a lawyer could read Jones to stand for the proposition that it is not necessarily willful disregard or deliberate misconduct to decline to follow the instruction of a supervisor about how best to get things done when you have a better way of getting things done that's actually more beneficial to the employer. I'm not suggesting it has to be read that way, but that's not crazy.
I would say in Jones that, again, there was no harm to the employer's interest at the end of the day. And each of these cases need to be decided on their own facts and circumstances. That's what this court has said. Again, there's rarely going to be direct evidence of intent. And the difference between...
Her perception, it seems to me, would at least inform us on some level as to what her intent was. Her perception of what the requirement was. No?
Well, I would read her testimony as that was her justification for her action, not that it was her perception of what was required of her.
I mean, just because the employee was harmed doesn't mean that there was like an intentional wrongdoing.
That's right.
It's not what that means. And so here, it seems that doesn't shrinking the screen, isn't that in the best interest of the employer? Isn't that, by shrinking the screen, isn't that not willful disregard of the employer's best interest?
It's not, because the employee was aware that someone could simply reopen the screen. And that's compromising the employer's interest in maintaining this very important patient information that they are legally required to maintain. I see my time has expired.
I think we understand the argument.
Thank you, Your Honors.
Thank you. Matter stand submitted.
We need to minute. We need 1 minute. Just
Oh, wait, did you? Yeah, we'll now hear from your colleague, Attorney Gelfman.
Good morning, Your Honors. Jack Basilakis on behalf of Boston Medical Center. BMC fully joins with the AG's office, the arguments presented before. I want to underscore just the critical importance of patient confidentiality and how the appellant's actions impacted confidentiality in that regard.
Why no brief?
We decided to join with the arguments of the Attorney General's office. So at BMC, as any hospital, staff deal with sensitive, confidential patient information every single day. It's the core of providing quality patient care, patient trust, and as my sister has stated multiple times, legal obligations as well as ethical obligations. Here, the appellant's actions created a real risk for breaching confidential.
Sure, I think we're all on the same page on that one.
Yeah, absolutely.
At this point, in hindsight, and that's why she got fired.
Yeah, absolutely. And then,
but don't we have to then? That's not really what, as I think Mr. Salgado said. That's not really what we're talking about here. That's not the inquiry today, right?
Understood. So for those reasons, we'd ask the court to affirm.
Thank you.
Thank you.
Attorney Basilakis. Matter is submitted. So our last matter on the docket today is 25P 0261. RONDOUT Group Advisors and another versus Fresh American LLC and others.
May it please the court, Your Honors. My name is Jim Tuxbury. I'm counsel to the appellee Pinecone Hill, PCH, as defendant in the underlying action, as well as the appellants Fresh American LLC, James Crane, and Annie Selke. We have a lengthy brief and cross briefs. There are 4 issues I'd like to talk about with you today. And
lengthy briefs and cross briefs and reply briefs and serve reply briefs.
And very lengthy record appendix, which really brings us to the question of what are we doing here in summary judgment, which is really the core argument we have here. We are in I would posit, an unprecedented setting, because I'm aware of no Massachusetts court in which a plaintiff was awarded summary judgment on a 93A claim based on a breach of contract.
Is that, and I don't mean this, well, maybe I do. Is that why you didn't cite any Massachusetts cases? Is that your brief? I mean, we had a lot of
Federal
cases, and we had some
unpublished Superior Court cases.
But we're the appeals court here.
Yes,
in Massachusetts.
We have the general principles from, Jurasan about that you need more than a breach of contract to have a 93A under a breach of contract. We have Atkins. But yes, some of it is born out of the fact that these kind of decisions never rise out of the trial court level. It is the unique nature of it, because you look at the record, the standard is whether or not there's a toehold of disputed facts to deny summary judgment.
So what would you say is your best controlling case?
I guess I would say Jurasan. H1 Lincoln is very compelling for us, because that's a case in which the court and my brother relies on an SJC decision where the court affirmed a finding of 93A in the breach of contract setting. But in that case, the contract at issue, the breach term was a site approval, and the defendant was refusing to give that site approval. And the SJC said, but the leverage for purposes of the 93A were 2 extra contractual concessions that he wanted in exchange for that complying with that contractual term. So there's a finding of bad faith, but there it was, he wanted a property to be transferred to him for $1 that was valued at $900,000, and And the second part was he wanted to limit the scope of property that could be used under the contract. So what you had there is you had the SJC expressly saying the leverage was these two other things. The court wasn't saying, as we have here, your payment dispute, right?
Well, isn't that the leverage? The leverage is take $900,000 less.
Or pencils down.
Yes, well, a couple of factors to that.
So isn't that arguably the leverage?
Well, no, that's
to the very end?
Well, I think under this setting, you need a good faith dispute. You know, a genuine dispute by itself is not 93A, right? And the evidence in the record is overwhelming that this was a genuine dispute.
Well, I'm not sure about that.
Okay.
Tell me on that. Let's
Certainly,
start there.
certainly. I think when you look at the trial court's decision, the trial court starts on page 16 when discussing 93A. The statement at the outset is, defendants repeatedly and forcibly threatened to withhold payment. No citation in the decision.
The charge was to get, I'm going to say Ms. Selke, is that how you pronounce her name?
Yes, Selke.
Controlling interest in the company. That's what you were bringing Garcia on to do, Garcia and Dalkeith, I think. Is that how you pronounce it?
It's RONDOUT and Dalkeith, two companies, but they were effectively one operated by this individual Garcia. Yes.
And so we're bringing in RONDOUT and Dalkeith.
Yep.
To get the predominant shares in the hands of Ms. Selke.
Yes, and
they did that.
No, they didn't do that, Your Honor. We have ample evidence that the plaintiffs tried to sabotage the transaction. For example, prior to the emails that the court emphasizes in mid-December, the one about pencils down, on December 6th, plaintiffs tried to sabotage the transaction by telling the only equity investor that they had identified for the project.
I saw that claim. When the deal closed, what was her holding? What was her interest?
She acquired the interest of PKI.
That's what the charge was for her, right?
No, I would disagree with that, Your Honor. This was a contract that required the plaintiffs to perform certain duties, to perform in the highest professional standards, to act as her exclusive financial advisor, to use reasonable efforts to raise money.
Toward what end?
That is the ultimate end, but in the question of a 93A context, and let me just back up, what you're saying is, do you have a legitimate argument that they breached the contracts? That's what you're asking. Rowayton, the case we cite in a footnote in our brief, and again, this is not argued prior down below, states that in these kind of arrangements, the manner in which performance is done is a material term, and the finder of fact needs to assess whether that was breached.
Is that a Massachusetts case?
Yes, it is. I believe it's a district court, though, case, Your Honor.
You mean?
You mean the appellate division?
Oh, no, I'm sorry.
Is it Massachusetts as in federal district court? Because I think somebody cited, I see an appellate division, a district court case cited somewhere too.
So
that's federal law. I mean,
well, it's applying Massachusetts law.
Cases for us. Go ahead.
It's applying Massachusetts law for how we interpret contracts.
By a trial judge.
Yes, by a trial judge. But I guess I would posit there's no authority that's identified by the trial court below here or my brother that suggests the plain language of the contract doesn't govern. And the plain language of the contract says, in exchange for consideration, you will do the following. Not you will simply close the project. And here from a 93A perspective, there's ample evidence, and I'd like to get back to your initial point, Your Honor, about convince you that they had breached and that we had a genuine concern about the breach. So part of this project, Your Honor, and then I guess the misinterpretation of the pencils down, which I believe is a disputed issue of fact that would bar summary judgment. And that is this. Underlying this transaction, Your Honor, was a post-transaction agreement that was reached called a Memorandum of Understanding, in which Mr. Garcia and RONDOUT stood to make significant sums of money. What came to light in late November was that RONDOUT and Dalkeith were trying to structure the transaction to personally benefit themselves in that post-transaction setting. They were making misrepresentations about Ms. Selke's compensation. They were not following the directions. Ultimately, on December 4th...
So let me just interrupt you for 1 second. So when that came to light, did you terminate the agreement with them?
She terminated the Dalkeith agreement.
Did she terminate the agreement with RONDOUT?
No, she did not.
How long did she terminate the agreement with Dalkeith before she reinstated it?
I don't think she ever reinstated it. Dalkeith agreement is terminated on its face because the Dalkeith agreement required Dalkeith to participate in the financing. and they did not participate in the finance. They did not invest in the project. So that was a term of the project of their payment, as we've argued here below. But, so the Dalkeith agreement on its face was terminated.
So they never got paid?
No, they've been paid. They've been paid.
So I don't understand. So help me understand why you'd pay them if you terminated their agreement.
Certainly, Your Honor. This was a dispute. This was a run-of-the-mill contract dispute. We had told them, as of December 9th, they notified us that there was no equity investors. Without equity investors, the project was closed. The project's slated to close on December 20th. There is no way and there's no evidence in which the PCH would have voluntarily not gone through with that transaction, because under the irreconcilable differences provision of that contract, Ms. Selke, who founded this company, grew this company, I mean, she literally founded it out of her garage, she would have lost control of that company. Because under this irreconcilable differences provision that the plaintiffs had suggested she trigger, it gave her the opportunity to buy, but if she didn't close it, the transaction.
Can I just, you lost me a moment, because I think, and I don't, but Justice Desmond's question was, as I understand it, I'm sure he'll correct me, is if they terminated the relationship, why would your client pay out the full value of the contract? Is that about right? Yeah. Okay, and I'm not sure I heard that one in the answer.
$1 million to Dalkeith.
Yeah, about
Yes,
$800,000 or
so
so?
I guess what I apologize for that. I was getting back to the explanation of it. So we are telling them we'll discuss what we think is a fair fee because of the misconduct you've done. And I'm giving that context.
When does that start? When does that conversation?
When is that starts within December 13th. December 13th, December 17th, Exhibit P31.
Was the fair fee the full contract price?
What's that?
Wasn't the full fee the fair fee the full contract price, or no?
No, because
All right.
because of the breaches, Your Honor. And this was a settlement effort. The suggestion, the view of my client is that they fully breached both contracts and aren't entitled to any fee. But we're willing to discuss settlement with them to reach that. And after the transaction closed, attorney for PCH contacted plaintiffs, said, let's talk about the fees. Because again, because of their failure to do the work, PCH had to go out and find investors, had to pay additional monies to do so, had to expend different efforts to make sure that they were able to close the transaction because of the catastrophic impact if the transaction doesn't close. And plaintiffs, as we put in our brief, were using that time pressure, the need to close or lose control of the company, and not just lose control of the company she founded, sell it for 30 cents on the dollar. We're talking about tens of millions of dollars. The suggestion that there's undisputed evidence in the record that PCH would go pencils down and close the transaction just to save $900,000. There's literally not a single shred of evidence in the record that says that.
So,
Isn't that what Attorney Crane said? I thought that.
No, that's not what Attorney Crane said at all. It's not what he said at all. What he is saying there, Your Honor, is that at that point in time, December 13th, there's no equity. The day before, contrary to the directions of Annie Selke and PCH, plaintiffs contacted the debt investor, Rockland Trust, and tried to change the terms of that debt deal. At that point in time, December 13th, there's a real risk the transaction is not closing. There's no equity. There's no investors. The only move that Annie can make at that point in time is to try to make good with PKI. So they don't essentially do the opposite to her. They don't say, we're going to buy you out for 30 cents on the dollar.
Then I'll let you get back to it. But as I understand it, the agreement was for PCH to pay Dalkeith $850,000.
Yep.
And then what do they pay him?
Well, ultimately,
They paid him $850,000.
Yes.
Okay. And the agreement was to pay the other party $1.25 million, and that's what they paid him.
But subject to reservation of our breach of contract counterclaims that we have filed by that point in time. So here's the procedural structure, Your Honor, and I appreciate the concerns you're
No,
raising.
I'm just saying, when you're talking about settlement and negotiation, it looks to me like a settlement is just, here, we'll pay you what we owe you.
So no, here's the way. Oh, sorry.
1.2, right?
2.1.
That's what you started with.
Yes, but after the deal closed, PCH contacted, says, let's talk settlement fee. The next day, they don't respond. Mr. Garcia has ceased talking to us and provided misrepresentations about why he's unavailable, okay? The next day, they filed a complaint. Within 2 weeks, we agreed to put the money into escrow to have a court adjudicate whether or not there was a breach or not. We assert counterclaims. In the context of this case, we make the business decision to say, fine, let's just change the procedural posture of this case. You have the money, now we're suing to get it back.
So you are suing to get it back?
100%, Your Honor. We are 100% suing to get it back. There are counterclaims in this case that lay dormant for 4 years.
Well, when you say there are counterclaims, are you talking about the claims that you sought to amend?
Yes.
Okay.
I spoke out of line, yes.
That's okay. I need to ask you a higher level question, and this is going to sound crazy, but as someone who has spent a fair amount of time with this record over the past few days, are there any undisputed material facts here?
I would say what's undisputed is that there was no coercion, no stringing along, no...
Well, no, that's not undisputed, because Mr. Berthium is going to get up and dispute that. So that's not undisputed. So, I mean, here's what I think I see as undisputed. There was an effort for Ms. Selke to gain control of this company after having lost some of it following a divorce and a restructuring. She retained Dalkeith and Rondout to help her do that. There are 2 contracts, written contracts, that describe those relationships. They include a payment term. That's about everything I can find that's agreed. Have I missed anything?
Yes, I would say what's also undisputed is that Selke and PCH raised concerns about the job performance of both those parties in November, December of 2019. Right, raised genuine concerns that they had breached.
And is there, in the 2 statements of so-called statements of undisputed material fact with responses, is there one that actually says that?
Yes.
Where?
Yes.
Where can I find that?
I
have the whole thing right here. It's magic.
I know. I apologize, Your Honor. I don't know that specific thing, but I know that we put in our reply brief the fact that these are statements that are made. In other words, it's undisputed that Annie Selke and Jim Crane made statements to Mr. Garcia about frustration about the misrepresentation about the compensation.
Not to be fresh, was that in the reply or the reply? Just so I can find it.
I think we only have a reply.
Oh, so they have the reply.
Yes,
All right,
yes.
sorry. Yeah,
and we put that in there, Your Honor. My colleague here, maybe she can pull that citation, the SOF for me.
When in the agreement did that happen? I mean, at no point did they fire Rondout. Right? You didn't terminate the agreement with Rondout.
No, they did, but I don't think...
They didn't fire, Dalkeith, I think they fired him and then brought him back because they learned without Dalkeith, there's going to be not enough funds to close the deal. And that was even less favorable to them. So
that's not accurate on the record, Your Honor. The Dalkeith agreement was terminated. They never invested, which was a term of their agreement. Right? That's undisputed.
How did they get paid?
We put the money in escrow at the request of them, just simply as a good faith. This was not an effort to steal money. This is basically a genuine contract dispute. My clients thought that he failed to perform, that he was trying to sabotage the transaction, that he wasn't using the reasonable efforts that his contract required him to do. They had to go out and find their own investors.
So you didn't pay it out, you put it in escrow?
We put it in escrow, yes.
Is it still in escrow?
No. A year into it, we decided to change the posture.
I thought it was paid. I thought you paid them $2.1 million.
Exactly, subject to our motion for leave.
Let's not mix words, okay? I mean, it's not helpful to you, I'll be honest.
Fair. We paid subject to a reservation of rights to sue back for the money, which is subject to it. And and I think, Your Honor's overall on the record, the question is, is there evidence, undisputed evidence, that we didn't have a genuine belief of a dispute of a contract claim? And on that, I would say there's not. There's affidavits of Annie Selke, there's affidavits of Crane, affidavits of Calora, there's contemporaneous documents. And with respect to this threat, Your Honor,
what's the first, I'm going to say, notice that you gave to Rondout that you were unhappy with their work performance? And when was that? What date was that?
That was November, sorry, Your Honor. I believe it was November 21st, 2019, expressing concerns, basically saying, why did you waste everybody's time here? You should have been more honest with me about what you were doing. That's Annie Selke expressly telling them, we wasted our time. And that
deal closed when?
It closed ultimately December 27th. It was supposed to close December 20th.
So November 21st, you said the first notice,
and
yes. The deal closed on December?
Yes, and then there were serial ones between...
a month later.
Yes, and there were serial ones between then and then. And in the course of discovery, Your Honors, we've learned evidence of fraud and misrepresentations by the plaintiffs in an effort to sabotage the transaction. And I would posit, Your Honor, from a summary judgment perspective for 93A, there needs to be some type of bad faith showing on behalf of PCH. We can have a dispute, Your Honor, whether or not the contract says we have to pay no matter what. Our client believes that the contract had certain terms that they had to comply with. So the question for summary judgment on 93A is, can the plaintiff show undisputed evidence that that position was in bad faith? The affidavits themselves preclude such a finding. The other evidence preclude that finding. The record, and I would posit the trial court didn't even make such a finding of bad faith. We had a genuine...
I see that's your time.
And I apologize, Your Honor.
Thank you.
May it please the court, my name is Mark Berthume. I represent plaintiffs together with Ali Holdway from my office. Let me clarify a couple things that came up in my brother's argument. First of all, with respect to payment of Dalkeith, there was no payment that was made. The closing occurred on December 27th. At that point in time, under the unambiguous language in the contract, the completion fees were due. She had acquired a majority interest in Fresh American. That was the material provision in both agreements. One, that we're going to go out, we're going to work for the next 10 months to get you a majority interest. We're not going to get paid. We only get paid if it closes. If there's no closing, we don't get paid, you don't get your majority interest. The contract is unambiguous in that regard. In fact, even if they were terminated, and it closed thereafter, within 12 months of termination, you were entitled to get paid in full.
All right, so Dalkeith didn't get paid. Were they terminated?
So during this process, while they were attempting to extort this reduction in the 2.1 that was due.
When did that begin?
On December 20th, there was an email sent, Dalkeith, you're terminated. They realized the next day that there couldn't be a closing without Dalkeith. There were emails. That's clearly in the record.
Right, Ms. Hunrod, he had a relationship with someone.
They're the placement agent. You can't get your equity investors without Dalkeith as placement agent. So Dalkeith continued to work, do the work over the next 7 days, and the deal closed. The deal closed on December 27th. Nobody was paid a dime, consistent with the threats that they had been making for the last month. Thereafter, we were forced to file suit on January 20th. No payment was made after the closing.
I want to fast forward you because you don't have as much time as you want. There was a payment made on September 8th that you call the September 8th transfer. I understand it is not in your client's interest for you to characterize that as a payment on the contracts, and so you don't. That's your choice. But that is the payment. When we are asking about wasn't there a payment, we are talking about the thing you call the September 8th transfer. Your clients received that, correct?
Correct.
And it's $2.1 million, correct?
Correct.
Okay.
So on January 20th, file the action, seek a trustee attachment to attach this $2.1 million in funds. Agreement is reached to a stipulation to escrow the money with the bank as opposed to do it by way of trustee attachment. Litigation proceeds. 18 months into it, after the summary judgment motion is pending, the defendants suggest we're going to transfer the 2.1. It was accruing interest at, obviously, at 12% prejudgment interest on the amount that was due. They said, we'll convey the 2.1. We're reserving all our rights. We're going to go after it. We took the 2.1. There was still additional claims that we had for the costs that were incurred and so forth. So the case continued. The breach of contract case continued. The 93A case continued. But we were holding the 2.1 instead of the bank. They were going to seek its return.
Can I show maybe a simpler, at least for me, question to crystallize this. Do I understand correctly that you are not claiming that there are no disputed facts? You're saying that, at least on the undisputed facts, as a matter of law, you win.
Correct.
Okay. Because in all of this, you acknowledge that there's lots of disputes.
There are many disputed
But you're saying it's not material because if you look at the package of undisputed facts,
we're not only entitled to a breach of contract, correct? I mean, the foundation for the 93A.
But on the extortion as well.
For Judge Campbell's 93A finding was that based upon there are undisputed facts that demonstrate that they were in material breach of the contract on December 27th when they failed to pay the completion fee. That completion fee, as a result of their having delivered the majority interest in the company, their failure to pay that was a material breach at that point in time.
And so what are the undisputed facts and where will I find them in the record? Because I have never seen joint statements of undisputed material fact that contain so little agreement.
Well, I mean, the undisputed facts to support what I just stated is the agreement itself. There's no dispute that there was this written agreement signed by the parties. The obligations set forth in the agreement are undisputed. It's undisputed that there was a closing that occurred on December 27th at which she received the majority interest, and it's undisputed that they weren't paid on December 27th.
Right. But what is disputed is they say that that you weren't meeting your end of the bargain because you weren't acting in the highest professional conduct, and that they were calling that out along the way.
Well, I mean,
and so because you breached, is their argument.
And the Judge Campbell, the Superior Court addressed that. Those contentions, few if any were actually in writing, but based upon affidavits, they made certain statements. But those statements and the alleged breaches that they've alleged are at best immaterial. There's no basis for many of them in the contract itself.
When would you say was the first one? When would you say was the first time that they said, we don't think you're meeting your end of the deal? The first time is in a December 27th email in which they note you failed to get the equity. That's the first time in any of these emails about settlement or you got to take 1.2 and take 900,000 off. There's never any reference to any of this in any of them. What about you trying to undermine our position? What about you not acting in accord with the highest professional conduct?
I mean, this came after, right? I mean, this is part of this litigation.
saying that's after the closing.
Correct. At this point in time, at the time of the closing, the only thing they suggested was we hadn't gotten the investors, meaning that there was they hadn't found one or two of these investors that came in, which is wholly irrelevant. I mean, frankly, the deal didn't even require investors. I mean, the deal was either loans or equity sufficient to take them out. And they ultimately obtained, through this incredible effort, $30 million, $25 million in loan, $6 million in equity investors that closed on December 27th. She went from having a 45% interest to a 73.5% interest in this entity that was worth obviously much more than $30 million. And they were trying to extort a $900,000 concession.
Why?
Why?
Yes.
Why were they doing it?
Yes.
They were trying to get something for nothing. They were trying to get something for nothing. I mean, it's...
Is that a 93A violation?
Absolutely is. I think commercial extortion is clearly a 93A violation. We've cited numerous cases, and that, the commercial extortion, is undisputed. I mean, we've referenced these emails that in which it could not be clear, and that's why it's undisputed.
Well, but they say it couldn't be clearer, that it means something different. So how is that undisputed? We can't decide what it means. That's not what we do here. We decide if judges got it right or wrong. We have a very limited role.
As understood. But it's undisputed that these emails were sent by PCH through its lawyers to us. The language of these emails speak for itself. And let me just note, for example, this is December 13th, 7:25 p.m. This is at Volume 1, 412. This is an email from Crane. We also need to address the issue of the Rondout Dalkeith fee. And it goes on, you know, it's been our daily 7 a.m. call. On this Pedro, we need to come to a resolution by close of business Monday, or we will handle it post-closing. All right, so there's the first time. And so they're saying, we either come to an agreement, or you're not going to get paid at closing, we'll deal with it after closing. On Joint Appendix 1-413, again, Mr. Crane, and that's 10 minutes later, that same day.
I'm sorry, what page are you on now?
This is December 13th, and this is Joint Appendix, Volume 1, page 413. Crane, in the worst case, and the deal doesn't happen this week, Annie is comfortable maintaining her relationship with some adjustments already discussed with Peter Kaufman, the entity being acquired. Her preference remains to close, as does Kaufman, but both parties are prepared for the alternative, right? So, I mean, clearly a threat that, listen, you either agree to take this concession, or we might not even close, right? And you're going to be owed nothing. And that's the one where it can close. If we don't close, it will be pencils down, and we will focus all our efforts on discussions with Peter Kaufman. So again,
how does that align with your argument that there was no dispute until after the time of closing, unless I misunderstood the argument? I thought I heard you argue that there was no dispute until after the closing on December 27th, and those seem to me to precede the closing.
Yes, preceding, there was an effort to reduce the amount that was due. I'm saying there's no statement in there,
because you
did
your
this,
malfeasance,
because you haven't performed, or because
No, I get the distinction. Fair. Okay.
Going on, and let me just go. I'll jump. There are a few more similar, and they're in our brief, so I'm not going to read them all. But on December 26th, the last day before the closing, Crane, again to my clients, hopefully settlement can be reached before we fund tomorrow. Final line, absent a settlement by noon tomorrow, neither Rondout or Dalkeith will be paid. Absent a settlement, you're going to get nothing tomorrow. I mean, this is undisputed. This is clear extortion.
If it is,
clear commercial extortion.
If it is, you think you're entitled to double damages?
Excuse me?
If it is, do you think you're entitled to double damages?
Absolutely, and for the reasons we said in our commercial extortion is by definition willful and knowing. This is not discretionary. We're entitled to multiple damages, and Judge Campbell, why she felt she had the discretion just to do fees and not to do a multiplier. Absolutely. I think as a matter of law, we are entitled to multiple damages. How else can we stop this kind of conduct? I mean, this is outrageous.
Do you rely on Anderson for that proposition?
Excuse me?
Is it the Anderson case that says that?
I mean, the cases are in there. I mean, the commercial extortion is I mean, Judge Gantz, I mean, one case I don't cite is Judge Gantz Superior Court opinion, God rest his soul, in which he granted summary judgment on the 93A, and I'll just give it to you so you have it. I only found it afterwards, but it's Gentle Communications LLC versus Nagar, Naggar. It's at 17 Mass Law Reporter 366. And I encourage you to take a look at what Judge Gantz had to say under similar circumstances. Thank you very much for your time.
Thank you. Matter stands submitted. Thank you both. Well argued. That concludes our business for the day. Thank you to our court officers and our timekeepers. Court is in recess.
Court, all rise.